Okay, let's see. There at Waxford, can you tell me your name, please?
It's Mr.
Ford Smith.
Mr. Smith. Okay. Okay. Are we ready on that case?
Can be, right?
Okay. We'll go on the record in People versus Ford Smith. This is case number 244896. The record should reflect Mr. Smith is present today by video from the Wexford County Jail. This is set for a status conference today, and then we have hearing on your motion to dismiss, Mr. Seeger. If I could have counsel put your appearances on.
Brian Ziegler on behalf of the people.
Thomas Seeger, on behalf of Mr. Smith.
Okay, Mr. Seeger, I did have a chance to review your brief as well as Mr. Ziegler's response. Is there anything that you wanted to present today by way of oral argument?
Your Honor, the only addition that I would make is the case cited by the prosecuting attorney somewhat, at least in my mind, somewhat buttresses my position that they're not members of the same household, they're residents of the same household. As much as the dissenting opinion in that case, it basically pointed out that that would conceivably include college roommates, although that was not decided by the court, and they specifically said, well, it's not before, so we're not considering it. Clearly, they were referencing it because they probably would have. I don't want to totally speculate. I guess they am somewhat to a certain degree. First, household is not defined anywhere in the statute. Second, I assume that if the court wished to define household as including the situation that they were describing, that college roommates are probably more intimate in that way because they're probably sharing rooms. So just by analogy, Your Honor, when I was in college, and I'm sure when you were in college, Your Honor, that you may have had a suite mate wherein, you might have shared a bathroom or something between the two suites. But I can't really say that that made us members of the same household. When I think of like household, I think of head of household. So in the case I decided, I think it was a mother and a daughter. Well, that's clearly a household, even if they're no longer living with each other. And when I file my taxes, I file taxes as head of household in certain years in which I'm able to claim my child. So I mean, like, it's difficult for me to say that even if they share common areas, that they're part of the same household, because they're really not. I think the analogy that I had written in the brief was, related to maybe somebody who's in prison. Well, I mean, they're sharing space, they're sharing common areas, but I mean, I really can't say that they're residents of the same household. This is a facility for which people are placed or actively go to, but it's not even like a situation where two people specifically intend on living with each other for, I don't know, for whatever reason, where they specifically chose to do that. It just happens that they're both at the same, for lack of a better phrasing, placing. But I can't say that it's a household. And so I personally think, Your Honor, that it should be characterized as an assault and battery, not as a domestic violence third. But I would otherwise rely on my brief.
Okay, thank you, Mr. Ziegler.
Just a couple points in response to that, Your Honor. I would largely rely on my brief. As to Mr. Seeger's point that Lovell somehow buttresses his position, it really does not. The only thing that Lovell decided definitively that the court can rely on was that the statute doesn't define household or define sharing a common household in light of the other factors in the statute. So it doesn't require a romantic relationship in the same way that having a child in common or being a spouse or former spouse would. The court expressly held that that was not the case. The court made no decision whatsoever regarding any further extension of the statute, which is exactly what the court's supposed to do under those circumstances. And the court's supposed to limit its decision to the facts of that case. If the court had expanded further and said, we find it would also be applicable to college roommates or to our current situation, that would be dicta, and the court wouldn't be able to rely on that anyway. So the only holding the court can rely on out of Lovell supports my position, which is to rebut Mr. Seeger's first point that it's limited to romantic partners. It is not. As to Mr. Seeger's second point, he seems to indicate that household should be looked at in the same light as for tax purposes when we talk about head of household, and that therefore roommates cannot be residents of the same household. I don't think it makes sense for the court to find a different usage of household in a completely different section of the law that has nothing to do with the criminal law and interpret it in light of how the tax code might define the term household or how some other code might define the term household. When the criminal law uses a term and it doesn't specifically define that term, the court should give that term its ordinary common meaning in the English language. So the court should interpret household, not necessarily how some other code has defined the term, but how generally people use the term household. And in this case, I think an AFC code or an AFC home, as it exists in this case, where they all reside in the same physical structure, they all live on one side of the duplex, they all have separate bedrooms, just like in a household with a traditional family, that all open up into common areas where they share living rooms, bathrooms, kitchens, etc., just like a traditional family household. To me, that is a completely analogous situation, and there's no reason that the legislature would have intended to protect people in that situation solely because they are familially related to one another, as opposed to considering the danger of those people being in the same situation around the same people who might pose a danger to them day in and day out. So for those reasons, Your Honor, I would ask you to find that household does encompass this situation.
Mr. Seeger, it's your motion. Anything that you wanted to say in response?
No, Your Honor.
Okay. Again, I did review the briefs of the parties. I had a chance to read in revolve, which I think is instructive in this case, and also highlights the problem that I think Mr. Seeger raises with the statutory language as it exists. And I really think that we either need to have some more definitive rulings by appellate courts or a change in that language by the legislature, or at least the addition of a provision defining what household means. Because I've had this come up in different cases. I had a case in Crawford County not too long ago where it was a situation where two brothers got involved in a fight. They hadn't lived together in 20 years, but at one point they lived together, and the statute says resided or has resided, or resident or former resident. And so the argument there was they were former residents of the same household. And the question is, does it make sense to apply a domestic assault to that situation where they haven't lived together in 20 years? They weren't living together at the time. They lived together growing up out of no choice of their own, obviously. And again, it creates these loopholes in the statute. Is that meant to apply in that case? That's different than here, of course, but it illustrates the point I think that Mr. Seeger's raising, which is there's trouble with the statutory language here when you get into what we don't consider to be traditional domestic relationships involving familial relationships or romantic relationships. So I think Mr. Seeger raises a really good point that there is gaps here. I think the case that I found that is not binding because it's unpublished, but does discuss kind of more of an analogous situation here, which is People versus Galladay, 2020 Westlaw 4723352. And in that case, the court found that resident or members of the same household applied to a defendant who was unrelated but lived in the same home as the victim. And that's kind of the roommate situation. They didn't share bedrooms, but they shared a household. They both lived underneath the same roof. And in that case, the court found that the domestic assault statute applied. So looking at Galladay as persuasive, although not binding, the court finds, number one, that there isn't a requirement that there be some kind of familial or romantic relationship in order to apply the domestic assault statute. And it doesn't have to be the offender's household, but it can be just a household that's mutually shared by two individuals. And so from a legal standpoint, applying those rulings to the facts here, the court finds that a reasonable jury could conclude that these individuals were members of a household and resided in the same household. So from a legal standpoint, the court finds that the motion should be denied because I don't think the prosecutor's legally precluded from attempting to seek conviction under that statute here. However, I think there's certainly a factual argument to be made at trial regarding the exact specifics of the living situation here. And I think it kind of leaves it up to the jury to determine from a factual standpoint whether these individuals were members of the same household. I think from a legal standpoint, the law supports a finding that they were. And I think, again, then it moves to a question of fact for the jury to determine. So I think Mr. Seeger would be within his rights to argue that they were under the same roof, but it wasn't the same household because of the fact that there were separate rooms and there were only certain areas that were common areas, or however, whatever the facts turn out to be. I don't think you can argue as a matter of law that the jury can't find that it's the same household. But I think from a factual standpoint, you can argue to the jury that the facts don't show that this was the same household. And maybe that's what the legislature intended by not specifically defining that term, is if there are questions of fact about whether or not it's the same household, it should be a matter for the jury. So all of that to say that the court is going to deny the motion. Mr. Seeger, if you'll prepare an order reflecting that. And then in terms of status conference going forward, do you want to reset this, Mr. Seeger, so you can talk to Mr. Ford?
Your Honor, I guess I would just ask the court. I did speak with Mr. Ford last week, and we determined that to the extent that the court did not rule in our favor, that we would just proceed to trial.
Okay.
But it may be helpful, Your Honor, if you gave us one final settlement conference. Maybe Mr. Ziegler will see things differently. But I tend to believe, because Mr. Ford's willing to have a trial, because I tend to endorse his position, it's right for appellate review to the extent that, you know, he's convicted, which I'm not saying he's going to be, but if he were, I think that the issue is correct.
Okay. Mr. Ziegler, do the people need any particular period of time to be ready for trial?
No, Your Honor.
And how many days of trial, Mr. Ziegler, do you think?
I would believe we could get this done in 1 day, Your Honor.
Agree, Your Honor.
Okay, so we'll set it for a 1-day jury trial at the court's next available date. The court will set it for a final status conference immediately prior to the trial date, motion day preceding the trial date. And that will be the plea and motion cutoff. Mr. Seeger, any other dates that I can address for your side today?
No, Your Honor.
Mr. Ziegler.
No, Your Honor.
All right, thank you. That's all for today. Mr. Ford, did you have any questions?
No, Your Honor.
Okay, thank you. The court's going to go ahead and disconnect at this time.
Thank you.
People versus Sue Ash, case number 244888.
Thomas Seeger, apparently looking at what happened to Ash.
Ryan Ziegler, yeah.
Thank you. Mr. Seeger, where are we at with this file today?
Your Honor, it's my understanding that Ms. Ash has been under a plea for an exchange on one of the.
Fair statement of the offer, Your Honor.
So that would reduce us to a 2-year.
Correct, Your Honor.
Okay, Ms. Ash, have you had an opportunity to speak to Mr. Seeger about this plea agreement?
Yes, Your Honor.
Okay, is that how you want to proceed today?
Yes,
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Ms. Ash, are you currently on any kind of probation or parole?
No, I've never been in any trouble.
Okay. You understand that the maximum possible penalty that you could face for this charge would be up to 2 years. Mr. Seeger, Mr. Ziegler, are there any SORA implications as an attempt here?
I believe there would be, Your Honor.
Okay.
Sora would say that a violation of certain statutes or an attempt or conspiracy, et cetera, to violate said statutes.
Okay, and you understand that in addition to the maximum possible penalty, that you'll be required to register on the Sex Offender Registration Act?
Yes, Your Honor.
Okay. With those things in mind, what is your plea to the charge of attempted accosting this morning?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights,
Yes, sir.
and you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the next higher court up, which is the Court of Appeals, to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty of this crime?
Yes, I am stupidly guilty.
Okay. So, Mr. Seeger, I don't have a lot of factual background here. It might be easier for you to ask some questions of Ms. Ash to establish a factual basis.
Ms. Ash, on or about January 1st of 2023 through September of 21st of 2023, did you send some text messages?
Yes, I did.
And was that particular person a minor?
Yes.
All right, and did you send those text messages in Kilcastle County?
Yes, sir.
All right, and were those text messages sexual in nature?
Yes, they were.
I don't have any further questions.
Was that individual under the age of 16?
Yes, sir.
Okay. And when you sent those messages, was it your intent to get that individual to try to engage in some type of sexual act?
It wasn't. No, no. It was, I was just having some fun with the person, and I just got carried away.
Mr. Ziegler,
All right, but you would agree that the content of the text messages was immoral?
Yes, yes, it wasn't right. No, it was wrong. It was sexual, yes.
all right, Mr. Ziegler.
Ms. Ash, was the content of that message encouraging the individual to engage in a particular sexual act, whether or not you intended to engage in that act with him?
I guess. Yes,
I think that would satisfy the statute.
All right, thank you. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Ms. Ash, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We're going to set this matter for a sentencing hearing. Before you leave today, you're going to meet with Agent Bear up here to set up a pre-sentence interview. And then you'll be notified of the date and time of the sentencing hearing. It's important that you follow up with him for that pre-sentence process and that you stay in touch with Mr. Seeger prior to the sentencing hearing, okay?
yes, sir.
Thank you.
Yeah, I do have a couple of things I have to take care of, but the growth is up next. Actually, I think there was one filed before us, but I just wanted to notify the court, and I did send an email to your clerk this morning, indicating that the growth is currently hospitalized. I don't have an actual piece of paper, but she did send me a screenshot of her wristband showing that she's
108.
hospitalized. I did send that to the court and to Mr. Ziegler.
All right, I did see that this morning. Mr. Ziegler, does it take, people take any particular position on that?
Your Honor, under the circumstances, I would not object to the court simply rescheduling the matter.
Okay, so this is People versus Cassandra DeGroat, case number 244913. Ms. DeGroat is not present today. I am going to set this for a show cause. I saw the picture. I have no idea what the wristband had today's date on it, but I'm going to ask you to let Ms. DeGroat know she's going to need to bring some further documentation.
I did tell her that, Your Honor, in the text message that she clearly needs to provide the court with some kind of actual fact. Not to say that the wristband didn't show something, but please give me some actual paperwork.
Right, okay, thank you. Okay, People versus Armstrong, case number 244900. You can be right at the podium there. That's good. Thank you.
Thanks.
Can I have counsel put your appearances on, please?
Ryan Ziegler, on behalf of the people.
Robert Curry, behalf of Mr. Armstrong.
Thank you. And Mr. Curry, can you tell me where things stand with this file today?
Your Honor, so I understand we've negotiated a plea, we're going to accept today.
Can you tell me what the terms of that agreement are?
It's my understanding if the Mr. Armstrong pleads guilty to use of an analog, it's a 2-year offense. I don't have the site statute.
Possession of analogs.
Possession, and also to a count 2 operating with the presence of controlled substance.
Okay.
The prosecution would dismiss the remaining counts, Judge, in the HOA.
Do you have the statute for that?
Your Honor, I'm not sure that I brought it with me.
Okay, you can get that to the clerk's office.
It's a 2-year and or I believe $2,000 fine.
All right, and are we going to take the factual basis to count 1?
The cocaine, yes.
Okay. All right, Mr. Armstrong, have you had a chance to talk to Mr. Curry about this plea agreement?
Yes, sir.
Okay, and is that how you want to proceed today?
Yes, sir.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Armstrong, are you currently on any kind of probation or parole?
No, sir.
All right, and as we've indicated here, you're going to be pleading guilty to an added count 3 of possession of an analog that carries with it a maximum possible penalty of up to 2 years and or a $2,000 fine. Do you understand that maximum penalty?
Yes, sir.
And then count 2, which is operating with a controlled substance. That's a misdemeanor that carries with it a maximum penalty of up to 93 days in jail and or a $500 fine with mandatory. Does he have a prior? Do we have to immobilize the vehicle here?
A prior OWI offense, Your Honor.
Yeah.
So unless it's
So 93 days and or a $500 fine. Do you understand that, Max?
Yes, Your Honor.
Okay. With those maximum penalties in mind, what is your plea to those charges today?
Guilty, Your Honor.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you'd have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we've said here in court today?
Oh, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Okay, this, according to the information, this happened on September 2nd of 2023, as far as you can recall. Is that the correct date?
Yes, Your Honor.
On that date, were you present here in Kalkaska County?
Yes, Your Honor.
And while you were here in Kalkaska County, were you operating a vehicle on M72, a highway here in Kalkaska County?
Yes, Your Honor.
And prior to operating that vehicle, had you consumed controlled substance, cocaine?
Yes, Your Honor.
And did you have cocaine in your possession?
Yes, Your Honor.
And did you know that that's what that substance was?
Yes, Your Honor.
Did you have any legal right to have it at that time?
No, Your Honor.
Okay. Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Curry?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Curry?
No, Your Honor.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr.
Yes,
Curry?
Your Honor.
Mr. Armstrong, the court finds that your plea is knowing, voluntary, and accurate, or to satisfy that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for, or these charges, I should say. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with your attorney prior to that. And then before you leave today, you're going to meet with Agent Barrow to set up a pre-sentence report. Thank you.
Yes, Your Honor. Thank you.
Okay.
I do want to state for the record, because I forgot to do it, People versus Ford Smith, case number 2448996. We did go on the record on that case at 9 a.m. I forgot to click the button. So, purpose of the transcription later, go back to 9 a.m. All right, ma'am, is your name Samantha Webster?
Yes, sir.
Okay. We are on the record now in People versus Samantha Webster. This is case number 234801. The record should reflect Ms. Webster is appearing today by video from Grand Traverse County Jail. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
John Seeger appearing as the arraignment attorney.
Okay, this hearing was set really at Ms. Webster's request for arraignment on a probation violation. Before we get too far, Mr. Seeger, did you have any opportunity to speak with Ms. Webster?
No, Your Honor. However, in speaking with the probation department, Ms. Webster, it's my understanding that they're recommending unsuccessful discharge and credit for 211 days.
Okay, and I'll give Ms. Wagner a chance to go through that as well. But thank you for that. Ms. Webster, are you aware of what the alleged violations are?
No, sir, I'm not.
Okay, so the bench warrant was issued back in October of 2023. It alleges at count 1 that you violated condition 2.8 of your probation in that you failed to report on or about October 3rd, 2023 to addiction treatment services. And then count 2 alleges that you violated condition 4.16 of your probation for basically the same conduct on October 3rd, 2023, failure to report to substance abuse treatment as ordered. Do you understand what the allegations are?
Yes, sir.
Okay, you do have the right to have a hearing as to whether or not you violated your probation as alleged. You also have the right to have an attorney present at any subsequent proceedings if you could not afford an attorney, one would be appointed for you. Mr. Seeger is here present in court today for purposes of this hearing today. And if you want to consult with him at any time, let me know and I'll give you the opportunity to do that. If you are found guilty of violating your probation, the maximum possible penalty you could face is that penalty under your underlying charge, which, Ms. Wagner, do you have that handy by any chance?
It's a 4-year.
Okay, which is up to 4 years. So do you understand all those things that I've just stated to you?
Yes, sir.
Okay. And did you want a chance to talk to Mr. Seeger, or how did you want to proceed today? It sounds like.
Honestly,
Oh, go ahead.
sorry, honestly, I just want to plead guilty to it and get it over with. I have a chance to go to community corrections and treatment here, here in Grand Traverse County. I've got 10 months. I get out in September. So I have to have this lifted to be able to go to treatment and go to a sober living.
All right, Ms. Wagner, do you have any objection to proceeding that way?
I don't, Your Honor. I just asked that the court take her plea to the counts, and I was recommending she has credit for 211 days total today, that she be discharged unsuccessfully from probation. I spoke with community corrections. They are ready to get her into a sober living home and into outpatient treatment and place her on GPS.
Okay. All right, Ms. Webster, do you want to have a chance to talk to Mr. Seeger about this before we go forward?
No, sir, I think I'm okay.
Okay, can you raise your right hand, please?
Yes, sir.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Ms. Webster, you understand that by pleading guilty, you're going to be giving up the right to have that hearing, as I said?
Yes, sir.
Okay, and also by pleading guilty, again, the maximum possible penalty you could face would be up to 4 years. You understand that?
Yes, sir.
With those things in mind, what is your plea to the probation violations today?
Guilty.
Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you did violate your probation?
Yes, sir.
Okay, on or about October 3rd of 2023, were you on probation out of Kalkaska County?
Yes, sir.
And were you aware that the conditions of your probation required that you report to substance abuse treatment if it was ordered by the court or by your probation agent?
Yes, sir.
And did you fail to do that?
Yes.
Okay, the court finds that the plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you did violate your probation as alleged. The court will accept the guilty plea. You've heard what Ms. Wagner is recommending for the sentence. I'm inclined to agree with her on that. But you do have the right to have this sentencing hearing set on a separate date and to have an updated pre-sentence report prepared, Ms. Webster. Do you want to go forward with sentencing here today, or did you want to have
Yes,
it set
sir.
for later? Do you want to have an opportunity to talk to Mr. Seeger about your options regarding sentencing before we go forward?
No, sir, I just want to get this over with.
Okay. All right, Ms. Wagner, other than what you've already indicated, was there anything that you wanted to say for the record today?
No, Your Honor, just that you sentenced her on October 3rd of 2023. You ordered her into inpatient treatment. She immediately absconded, didn't turn herself in. Her whereabouts was unknown until January 2nd when she got arrested in Grand Traverse County. She's been sentenced on a new case over there with that out date in September. This matter needs to be resolved for her to get into community corrections. So I would just ask that Your Honor follow my recommendation. Thank you.
Okay, and I know you already said this, but I just want to confirm the 211 days credit is accurate up to today.
That is, and that includes her previous, I think it was 57 days she had previously, I believe, or whatever her original sentence was, and then from her arrest from January 2nd up until today, for that total of 211.
Okay, thank you. Mr. Seeger, anything on behalf of Ms. Webster? I know you're only appearing in.
No, on behalf of Ms. Webster, and I am familiar with Ms. Webster, I think that much like many people who struggle with substance abuse, sometimes they make good decisions and sometimes they make bad decisions, and clearly not continuing on with treatment when she had the opportunity to do so was clearly a bad decision. But be that as a mayor, she now has the opportunity to get into treatment. Maybe Grand Traverse County will be able to resolve a situation for her that she's struggled to address. So hopefully the court will follow the recommendation and hopefully she'll successfully complete her treatment.
Thank you. Ms. Webster, was there anything you wanted to say for purposes of sentencing today?
No, sir. I admit to my mistake. I know I didn't go to treatment. I honestly don't know what I was thinking at that time, but after this new charge and being here for as long as I have, I'm really looking forward to starting a new life.
Okay, thank you. I did have a chance to review the file prior to today's hearing, so I'm familiar with the underlying charges and circumstances involved in this case. And given the nature of your new offenses, as well as the alleged probation, or I guess the probation violations here now in this case, I do think the recommendation is appropriate. Number one, you've served a significant amount of jail time. I think it more than adequately accounts for your negative behavior in this case and while on probation. So I don't
Yes,
find
sir.
that any additional sanction is appropriate. And I do think that it's appropriate to have you follow up with another attempt at treatment. At your age, you got a good likelihood, if you follow through with the treatment, of moving on from this. And I hope that your efforts this time around have a better effect than the first time, because, and I get it, relapses happen. Treatment isn't always something that people are ready to do when they're ordered to do it, but you sound like you're ready to do it now, and I hope that you are, because really that's the key.
Yes,
and
sir.
that's the only way going forward, is to follow through with that. So I hope that you do that. The court is going to, again, adopt the recommendation and sentence you to 211 days in the Kalkaska County Jail with credit for 211 days served. The court is going to discharge you unsuccessfully from your probation in this case. The court is going to preserve any outstanding fines and costs. Ms. Webster, you do have the ability to seek an appeal of the sentence. If you wanted to do that, you would have to request an appeal within the next 42 days and request a court-appointed lawyer within that time. We are going to provide you with your appellate rights in writing. So what I've just told you, you're going to get that on paper. So if you wanted to do that, you would need to fill out that paperwork. Otherwise, Mr. Seeger or Ms. Wagner, anything further that we need to address today?
No, Your Honor, I'm all set. Thank you.
Okay, thank you. Good luck to you going forward, Ms. Webster. That's all. We're going to disconnect at this time.
All right, thank you, sir.
Okay, so Mr. Seeger, I got the message that you need to speak with Mr. Brown.
If possible, Your Honor.
So if, and I think he just popped up here. If you want to sign on to Zoom, I can put you in a breakout room. Oh, maybe not. Is he in DOC? You know?
He is, or at least he was, Your Honor. I mean,
We're a few minutes early for his hearing, so I'm just gonna leave them connected. You can, Chris, if you can just let me know to bring him in that room, and then we'll come back out. We're already connected, so we don't have to worry about that.
I'm gonna look at it.
Yep.
yeah, I'm just gonna walk outside, or if that's okay.
Sir, are you Mr. Brown? Mr. Brown, are you able to hear me okay?
Yes, Your Honor.
Okay, so I'm going to connect you with Mr. Seeger, with your attorney. He wants to have an opportunity to speak with you before we go forward with your hearing today, okay?
Okay, thank you.
Your Honor, can you turn off the live stream? Oh, well, I guess we're going into a breakout room. Never mind.
Yep, I'm going to put you in a breakout room so you can have a private conversation.
Thank you, Your Honor. mean, other than. Okay.
Okay, Mr. Brown, are you able to hear me?
Yes, Your Honor.
Okay, we'll go on the record in People versus Brown, case number 244898. The record should reflect that Mr. Brown is present today by video from Michigan Department of Corrections. I'd like to have counsel put your appearances on.
Ryan Ziegler on behalf of people, Your Honor.
Thomas Seeger agreeing with on behalf of Mr. Brown.
Okay, thank you. Mr. Brown, for the record, Mr. Brown had an opportunity to speak with Mr. Seeger here this morning in a breakout room through Zoom. Mr. Brown, did you have an adequate opportunity to talk to Mr. Seeger and go through the pre-sentence report with him?
Yes, Your Honor.
Okay, Mr. Seeger, are there any additions, deletions, or corrections that need to be made?
No, Your Honor, originally we were going to object to some scoring, but in speaking with Mr. Brown, we would leave those.
Okay. Mr. Ziegler, do the people have any additions, deletions, or corrections?
So clerical error, Your Honor, on page 1 of the evaluation plan, last paragraph for the compass chart, says sentencing guidelines have been scored at 5 to 27 months. A straddle cell, that's a clerical error. It should be 5 to 17 months. It's an intermediate sanction, so.
Any objection to that change?
No, Your Honor.
Any other corrections?
No, Your Honor.
Do the people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, I think largely, and we've discussed this at the time of the plea, that the sentence in this case was not going to exceed the sentence in the Antrim case and that they would run concurrently. That's the recommendation here today. I think that recommendation is appropriate. There's nothing really more that we can do to him that Antrim has not already done, aside from the fact that he's going to be owing Kalkaska County a significant amount of restitution, which I think is appropriate given his conduct in this matter and the damage he caused to numerous police vehicles, both of this county and other counties. So I think the recommendation in terms of whether this is appropriate for the defendant's conduct, Your Honor, I'd ask the court to adopt it. I don't have any particular thoughts in terms of whether a community sanction or a prison sanction is more apt in terms of record keeping in this case, Your Honor, but ultimately I don't think it will make a difference one way or another to the defendant's outdate.
Mr. Seeger?
Likewise, Your Honor, and speaking with Mr. Brown, it's my understanding that his earliest release date is somewhere in the middle of 2026. And so whatever it is that the court does in terms of sentence probably will not affect his out date. So to that end, Your Honor, I would just ask the court to consider giving him credit for time served. He's been sentenced on a greater charge in Antrim County, for which he's doing a much larger sentence. So I assume that at some point in time he will parole to Antrim County as opposed to Kalkaska County. I guess if it's in but be that as it may, Your Honor, clearly he made a bad decision on that day. Part of the reason why the prosecuting attorney had limited the charges because he's already been sentenced for one long transaction or occurrence. And so just as a practical matter, I think it makes more sense to just give him credit for time served and close his file.
All right, thank you. Mr. Brown, anything that you wanted to say today?
That I like to apologize to the community and all the recklessness that I caused and endangering the officers and the public. And yeah, I was just in a bad place at the time in my life, and I take full responsibility for everything, my actions.
All right, thank you. I did have a chance, Mr. Brown, to read through the pre-sentence report. Contained a lot of information about what happened in this case. Also a lot of information, of course, about your background and your circumstances. And, you know, the facts of this case are, from a public safety standpoint, concerning to the court. I think bad decisions is really an understatement. You put yourself, you put the public in general, and you certainly put law enforcement in a great deal of danger over a pretty sustained period of time throughout this kind of 3-county chase that ensued after you decided to run from police. You put a number of officers in danger of serious injury or even death. Certainly put the public in danger by crossing the center line, and yourself in danger as well. So I think that your conduct in this case certainly deserves serious punishment. And regardless of whether the sentence in this case is kind of subsumed by your sentence in the other cases, I think it's important to impose a sentence here to acknowledge your wrongful conduct that was directed specifically at the officers here in Kalkaska County and the citizens of Kalkaska County that you put in danger that night. So I think it is appropriate to impose a sentence here. I think it's appropriate to impose the maximum sentence that the court can under the statute, which would be 16 months, given that the maximum here is 2 years. So the court is going to sentence you to 16 months to 2 years in the Michigan Department of Corrections. You do have credit for 198 days served. That sentence to be served concurrently with your Antrim County sentence. The court is going to order that you pay restitution in the amount of $4,612.61. That's payable to the Kalkaska County Clerk to be dispersed to the Kalkaska County Sheriff's Department. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the right to seek an appeal of this sentence. The court, if you haven't already received it, you will receive a written copy of your appellate rights that'll explain to you how to file for an appeal if you wanted to do that, as well as how to request a court-appointed lawyer to help you with any appeal. Mr. Ziegler, is there anything else that we need to address on behalf of the people today?
No, Your Honor.
Mr. Seeger?
No, sir.
Mr. Brown, that's all for today. Good luck to you going forward. And again, those appellate rights will be forwarded to you, and the court is going to disconnect at this time.
All right, thank you, Your Honor.
Mr. Seeger, do you know if Ms. Barney is present?
Yes.
I don't, if she's here.
We're bringing her out right now.
Oh, you are? Okay.
Yeah.
Ms. Barney, the podium there, please. Thank you. On the record in People versus Karen Barney, case number 244909. The record should reflect that Ms. Barney is present here in the courtroom today. They passed that for sentencing. Ms. Barney, have you had a chance to go through the pre-sentence report and talk to Mr. Seeger about that? Mr. Seeger, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, sir.
Mr. Ziegler, do the people have any additions, solutions, or corrections?
Brian Ziegler on behalf of the people. Your Honor.
Any challenges to the scoring? Anything on behalf of the people for allocution today?
Your Honor, the court probably recalls Ms. Varney was before you for sentencing on February 6th for possession of narcotics. At that time, Mr. Seeger stood before you, told you that Ms. Varney was doing better, and healthier, that she was substance free, and that she was serious about her recovery. When Ms. Varney addressed the court that day, she did nothing to dispel those assertions from her attorney, which he presumably only made at her prompting, or at the very least, he had made based on her representations that those statements were true. During the court's allocution, the court gave Ms. Varney 12 months counting time and told her that if she came back, there would be nothing left to do but send her to prison. The court's words could not have been more prophetic on that day, because just a few hours later, she was caught with methamphetamine and a makeshift smoking pipe in her jail cell right here in Kalkaska County. One can only surmise that she brought the methamphetamine into the courtroom and had it on her person the entire time the court was sentencing her for the prior offense. Ms. Varney's version of events at the time she was caught was that she found these substances in her mattress in jail. First and foremost, that's completely unbelievable on its face. It's even more absurd that she would then attempt to conceal those things from corrections officers. hiding them in her blanket and then saying sorry when she was discovered with them. Later, the defendant told the PSI writer she had turned to using methamphetamine a week prior to sentencing. Presumably, she's abandoned her story at that time about simply finding these substances in her cell. Ms. Varney's record does not recommend leniency to her in any event. She was convicted in February of this year of possession of narcotics, sentenced to 1 year, and committed this offense on the same day. Before that, she was sentenced to a year for possession of meth in 2021. She was sentenced to 8 months jail and 12 months probation in 2020 for possession of meth. She was discharged unsuccessfully from that probation term. Earlier in 2020, she pled to a larceny in a building in Grand Traverse, a possession of narcotics here, and a felony receiving and concealing in Antrim County. She has had opportunities to correct this behavior, and she has failed to take advantage of those opportunities. The guidelines are 29 to 57 months. Her sentence on this case is mandatory consecutive to a prior sentence, as it was committed in a place of confinement. While I'm not someone who generally agrees that incarceration is a solution to a drug problem, and I would suspect that the court does not believe that either, at some point, the criminal justice system is simply left with no alternatives but to prison and incarceration. And I think that in this case, that is where we're at, Your Honor. This is the defendant's 9th felony conviction. She's been sentenced to prior lengthy jail sentences in the past. She's been given opportunities for probation on the past. There's no choice but to impose a prison sanction at this point. As for amount, well, it's her first prison sanction, Your Honor. Guidelines are quite high, and I don't see that the nature of her violation would warrant anything on the lower end of the guidelines. Given her history and given the brazen nature of this particular violation, Your Honor, I would recommend a sentence of 48 months, which is slightly above the middle of the guidelines range for this offense, and it would be consecutive to her underlying 12-month sentence, with no credit for time served. It would be the people's position that this sentence, while seemingly high for the nature of the offense involved, is more than justified by her history, by the fact that her violation was committed in this very courtroom and this very jail facility, and in blatant defiance of the court's own admonitions that day. The defendant has fully earned her sentence, and the court should feel no compunction in giving her what she deserves. Thank you.
All right, thank you. Mr. Seeger?
Your Honor, by way of elocution, I'm somewhat very disappointed and saddened for Ms. Varney, as much as I really did have a good faith belief that she was on her road to recovery. And when I had talked to her during the points of the prior case, she had been indicating that she had been doing reasonably well. She was doing drywall and she was staying out of trouble. She was doing the best that she could. And I was happy that she had found some stable employment. Sounded like she wasn't using drugs. She had found another person for which she could rely on. And so I was hoping that she would find some stability. Unfortunately, that was not the case, Your Honor. Unfortunately, because she has such a severe addiction, she finds herself in the position that she finds herself in today. It's very unfortunate because she's a young person. She still can learn from this. She still can recover. When I look at her prior criminal history, I really can't dispute what Mr. Ziegler had said. Her records were replete with drug infractions, but they're all primarily drug infractions. And there's a reason why she continues to use drugs. Part of it is addiction. Part of it is some of the things that have happened in her life. She has, to her credit, while she's been incarcerated, engaged in services that she couldn't engage in. She did bring some verification. She did complete some classes to address some of her social history in the past, some of her underlying substance abuse problems. I don't really know what to make of it. On the one hand, like I really can't dispute what Mr. Ziegler is saying. On the one hand, bringing drugs into the jail is a bad thing because it not only endangers her, it also endangers or allows other people who have similar problems to use illegal substances. On the other hand, a person with an addiction is probably more likely to resort to things that are acts of desperation that a person who's thinking clearly and didn't have that addiction probably would not engage in. In as much as I understand why the prosecuting attorney is asking for a higher sentence, I'm asking the court to consider giving her a sentence that would allow her to get into boot camp if she's eligible. I do understand that the court has given her quite a few opportunities at rehabilitation. The court has given her a lot of opportunities at county time sanctions, but maybe because she's never previously been to prison, there's maybe a difference between serving a local term of incarceration and going to prison. There was an old judge who's now retired who used to say, you know, I think you just need to go there for a period of time. I'll allow you in boot camp, but I think you need to understand what prison is like. And maybe that's appropriate for Ms. Barney. If she's given a sentence, and this is my understanding of how boot camp works, to the extent that the court is going to allow her to get into that opportunity, is if she receives a sentence of 36 or greater than 36 months, she's ineligible for boot camp. So the guidelines provide for a sentence that would still provide for prison sanction, but would also still give her the opportunity to get into boot camp. I guess to a larger end, Your Honor, you know, anyone who has a drug problem, I want to help them address it, because in the end, they're probably likely to come back to the community. They're likely to continue to have larger problems that continue to result in criminal prosecution or long-term incarceration, none of which leads to stability. It only leads to poverty and people continuing to use drugs. And as children, and if she has children in the future, I don't want them to be involved in a situation where somebody's not able to get their substance abuse problem under control. And at least as I understand it, Your Honor, never having been to prison myself, drugs are somewhat readily available there as well. And so she's going to have to make a determination that she does not want to put herself in that situation going forward. And if she was maybe, you know, an older person, maybe I wouldn't look at it quite the same, but I probably would still look at it similarly, in as much as it's difficult for me to want to incarcerate somebody for a long period of time wherein they have a substance abuse problem. In this case, arguably, she's hurt other people in as much as she hurt the security of the jail, but she's not hurting someone in the sense that, like, she's not out robbing and stealing people so that she can maintain her drug habit. And at least she was working during this time period. At least she's tried to use her time wisely. And again, Your Honor, it's very unfortunate that we find ourselves in this situation, and I'm disappointed. I don't even know if disappointed is the right word, Your Honor, but I'm just very saddened for Miss Barney that she has created this situation for her wherein the court was very gracious in the last go around, wherein you essentially said, you know, Miss Barney, I hope I don't see you again, because if I do, it's not going to end well for you. Clearly today, it's not going to end well no matter what the court does. But in terms of giving her one final opportunity, because she's never been sent to prison, if she's eligible for boot camp, and even if the court later determines that, you know, you wanted to see how she was doing while she was there, if she was picking up tickets or what have you, ordinarily the Department of Corrections will send you a note or the court a note asking if this person's eligible. If she's doing well there, maybe that's a better time to make a determination of whether or not you would allow her to have a boot camp. But when we had originally entered into the plea, the prosecuting attorney had indicated, and I don't think his position has changed, albeit he's asking for a sentence that would render her ineligible for boot camp. He did not have an objection to her getting into boot camp to the extent that she was eligible. Maybe this is a learning lesson for her, wherein, you know, when you get there, you can better understand that there are greater consequences out there, and that if you're able to focus on yourself, maybe you can do better going forward. And the structure that she needs is probably through boot camp. Clearly, I've never gone through the program, Your Honor, but the people that I do know, or former clients that have gone through boot camp, have indicated that boot camp was very helpful to them in terms of structure, in terms of making sure that they're following certain edicts that maybe they weren't following in life. And so hopefully it has a similar like effect for her. It's difficult, again, Your Honor. If it was just her being in possession of drugs solely, and there was not the accelerant of it being in the county jail, I would probably just ask for a county time sanction of some sort. But recognizing that she was in the county jail, and recognizing the problem that causes for staff, security of the jail cell itself, you know, I understand why the court might be inclined to send her to prison, notwithstanding what the guidelines clearly bear. But be that as it may, Your Honor, she's just asking the court to consider giving her a sentence that would allow her to get into boot camp if she's eligible. And even if the court's not willing to say that she's eligible today, to the extent that her sentence reflects her ability to get into that program, she would just ask the court to monitor it. And if given the opportunity while she's there, if she's doing well, if the court would maybe consider endorsing that at a later time if it's not willing to do it today.
All right, thank you. Ms. Barney, anything that you wanted to say today?
I do. I understand being given chances to gain control of my addiction, and I failed to do that. I've also come to the realization that drugs turned me into a terrible person. I've convinced myself time and time again that my life isn't physical. I've met some pretty good people in the last few months that have shown me otherwise. I'm scared, but I don't feel sorry for myself anymore. To a normal person, that doesn't seem like a big deal. But it is to me, because I feel stronger. I feel like I can put this behind me at some point. I have a lot of time left in my life if I do it right.
All right, I did read through the report. Obviously, I'm familiar with you. I'm familiar with your background. I'm certainly aware of the circumstances regarding this charge. And I think one thing we can all agree on is it is sad. I don't think any of us wanted to be in this position, and that includes the prosecutor and me. I don't think anybody wanted this to go the way that it went. And I know you certainly didn't. So it's a sad situation, and it's too bad. But, you know, you have put the court in a position where the guidelines are what they are, and, you know, I can't save you from the consequences of your own actions here. You've had many times opportunities to get a hold of this issue. There's a lot of help available out there to you in the community, whether it's court ordered or not. But it's always up to the individual to take advantage of that help. And when you don't really leave many options for those of us in the system going forward. And so your guidelines are what they are. And because you brought the substance into the jail, it is dangerous. I deal with a lot of cases of people overdosing in the jail. We have deaths in the jail from people bringing in substances to either use themselves or have other people use. And so aside from the security and safety concerns, just from having people on substances in a jail environment, it can result in death. And that's why you have more severe penalties for that kind of conduct. I can certainly accept the fact that you weren't thinking clearly. If you're under the influence, you know, I get that. People aren't thinking like normal people when they're taking substances, especially something like methamphetamine, which really messes with your mind. Because I don't think a normal person would make the decision to do that under those circumstances. But again, I'm not in a position where I can save you from the consequences of your actions, because that's what happened and that's what you did. I also agree with Mr. Seeger. Prison is not a drug-free zone as much as they try to make it that way. And so you're going to have options going forward. You're going to have choices to make when you're in prison, and that's whether or not to continue on this road and get whatever you can when you can get it and use, or to take advantage of what is available to you from the Department of Corrections to work on yourself, so that when you are released, you're in a better position than you were going in. And there's certainly those resources available there as well. And so you're going to have to decide which direction you want to take while you're serving your time for this. I do think that a sentence in the middle of the guidelines is appropriate, because I think there are some mitigating factors here, and that is that you weren't thinking clearly when you did this. But there's certainly some aggravating factors here too: past history, your conduct in this case. All of that again leads me to a conclusion that a sentence in the middle of the guidelines is appropriate. It acknowledges your wrongful conduct in this case. It punishes you for that wrongful conduct. It hopefully provides a measure of deterrence going forward, but it also recognizes some of the mitigating factors as well. So the court finds that a sentence of Again, the guidelines are 29 to 57 months. The court finds that a sentence of 42 months is in the middle of the guidelines. And again, I think that's appropriate. But the court is going to sentence you to 42 months to 10 years in the Michigan Department of Corrections. Given the nature of this charge, it is mandatory consecutive to your underlying file 234864. And you do have 0 days of credit. The court is going to order that you pay a crime victim assessment of $130, court costs of $325, attorney fees of $350, and a state cost of $68. You do have the ability to seek an appeal of the sentence, and Mr. Seeger, if you can, Gary, can you get the appellate rights there?
Or for the record, returning a copy of her appellate rights and giving her a copy of some. I think that concludes my docket. However, I have one awareness that's going to handle for you at around 5, and I'm not sure speaking with the magistrate this morning whether or not we had 2 pre-trials that are coming into a meeting. Entirely clear to me. I think it was an add-on, your
Probation violation?
yes.
Okay,
So
at 11:45.
yes, sir. So I'll come back for that.
Mr. Travis, are you ready on Mr. Suarez's case?
Yes, Your Honor.
This is file number 244911. If I could have counsel put your appearances on.
Brian Ziegler, on behalf of the people, Your Honor.
Kyle Travis on behalf of Jeremy Borges.
Record should reflect the defendants present here in the courtroom today. Mr. Travis, how did we want to proceed with this case?
Your Honor, last time we were in front of you, Your Honor let us adjourn this for a month so he could pursue discussions with sobriety court. In the interim, he has had discussions with Becky from the sobriety court. The issue that has come up is he is now residing in Belleville, Michigan. He went to rehab, and after he kept going to rehab, felt that it was better to locate where he had more support and less factors of negative influence. Becky had indicated she was going to look into a bit if it was possible to do a transfer. I have done a little bit of looking, and one of them was at a suggestion Mr. Borges discovered at the testing facility, asking folks that I believe was the 35th district. They indicated they're not taking transfers at this time, but recommended 2 other courts for me to contact. Would be the 23rd and I think the 34th. It's a little different down there. There's Wayne County's got like a dozen or more district courts. I believe Belleville is the Romulus district court where he resides, but the Taylor district court is a regional, which like our own, it's a regional, but it's regional to Wayne County. Sobriety court, I've had some discussions with the probation officer there. So there's possibility of a transfer, but we're not quite there yet. That's where we stand.
So what are you asking to do?
I would ask for another 30 days to have the sobriety court team and Becky kind of see where they're, because there's kind of 2 things. One, Kalkaska's got to say, hey, we want him and we'll transfer him, as you know. And then 2, that the court down there has to accept him. The one court indicated that they will take a transfer, but they only take misdemeanors. And I don't know, and that's why I got to follow back up with them. If it's like Grand Traverse, where they'll take them on, if it's a delay, they'll accept it because Grand Traverse is a district court sobriety court. And they only take misdemeanors, but they'll take felonies on a delay package. This other court, there's a couple factors, basically, that I don't have absolute answers yet at the moment.
All right, Mr. Ziegler.
Your Honor, I would not object to another 30-day adjournment in this matter.
Okay. All right, so we'll go another 30 days, but if it's not done by that point, then we're gonna need to either get this set for trial or enter plea. But it's been going since March, it's now June, that'll be July, it's signed over, or since the charges. And I think by that point, we need to have a direction about which way the case is going. So we'll set this for a status conference in 30 days. And at that point, Mr. Large, you need to be ready to either enter plea and proceed with sobriety court or some other resolution. Okay,
That's right. Thank you.
All right. Thank you. People versus Trepanier, case number 244891. If I could have counsel put your appearances on.
Kyle Travis on behalf of Mr. Senior.
Mr. Travis, can you tell me where we're at with this file today, please?
Yes, Your Honor. Last we were here, we had asked for an adjournment, we did prelim transcript to look into some statute of limitation issues that came up when Judge Bidet actually directed or suggested, maybe I'm hair splitting there, that the information be changed. Mr. Ziegler and I went through the math, and as near as I can tell at the moment, even though it does change things and it is close, it does appear as though it's still 2 months within the statute of limitations at the moment. That was that issue. Given it's almost a 15-year-old allegation, there are still a lot of issues. At this point, we don't have a resolution. I don't know if we'll come to a resolution. We haven't had a ton of detailed plea discussions, and I don't know if that's necessarily where we're going to go. So if the court would like, not having a plea agreement, not even necessarily thinking we're going to get a plea agreement, I would say we can set it for trial, but I would ask the court for quite a bit of time. I was just discussing with Mr. Seeger that I've got to find an investigator, but that I think I need to get an investigator because a lot of the things that are coming up are, it's an old case, old witnesses, old things. And along with that, from the defense perspective, there is an interview that I guess I got to talk to Mr. Ziegler some more about, that maybe we probably need to get a transcript of, because I think that's going to have a lot of back and forth, because it relates to statements made after a polygraph, which is pretty replete with problems, an issue of things we can't talk about, but from the defense perspective, things I don't want it to just be.
All right, I don't think we need to go into all these specifics, but I agree with your assessment that we should get it documented. How much time do you want to have to do those kind of preparations?
I would ask for 120 days, Your Honor.
Mr. Ziegler, do you have any objection to that?
No.
Okay, so we'll set it for trial 120 days out. Mr. Ziegler, how many days of trial do you think we'll need from your perspective?
Your Honor, I don't have an overwhelming number of witnesses, but it is a CSC case. Typically, it might take most of half a day to pick a jury. I would set it for 2 days just to be safe.
Okay. Mr. Travis, what do you think?
I would say so. I think at this point we might have less than half a dozen defense witnesses. I don't think anyone's going to be an extensive amount of time, even if we do. And I agree with Mr. Ziegler. These tend to take a bit to do. So I think at least 2 days. I don't necessarily think we need 3, but I would want a day plus for trial and half a day for selection.
Okay, so we'll set it for a 2-day jury trial, about 120 days out. I will set it for final status conference. That'll be the plea cutoff. Mr. Travis, it sounds like there may be some motions that need to be addressed prior to a trial on this case. So you can file those and set them for hearing at any time, but no later than that final status conference date, okay?
Thank you.
Mr. Ziegler, in terms of scheduling, anything else you think we need to address from your side today?
There you go.
Mr. Travis?
No, Your Honor, thank you.
Okay, Mr. Trepanier, did you have any questions about how we're gonna go forward?
No, sir.
Okay, thank you. That's all for today then.
Thank you.
I wasn't sure where we were going.
Okay, Mr. Travis, I believe your client, I don't know, Mr. Wasnatus?
Yes, Your
Is that
Honor.
how you say it?
I think so.
Okay. He's appearing by video today, is that correct?
He is, Your Honor. Your Honor approved that. He is on a GPS tower out of Genesee, I think.
Looks like he's connecting right now. Okay. All right, sir, how do you pronounce your last name? Is it Wasnatus?
Wisdonitis, Your Honor.
Wasnitis, okay, thank you. We're on the record in People versus Brennan Wasnitis. This is case number 244914. The record should reflect that Mr. Wasnitis is appearing today by video by prior approval of the court. Both attorneys are present here in the courtroom. This is set for a status conference in this case today, or scheduling conference. Mr. Travis, can you tell me where things are at with this case?
Yes, Your Honor. So the complication, which isn't really a complication and may really end up having to be hashed out at sentencing, is there was an issue where Mr. Wasnitis a year ago didn't appear to court. Shortly thereafter, he then spent a year in the Genesee County Jail. And part of that is in discussing with Mr. Ziegler how we want to handle that. Because there's credit issues, there's non-credit issues, there's programming issues of what's going on in Genesee County and things of that nature. So largely we'd ask for a 30-day adjournment. The matter 99% will be resulting in a plea. So we just want to, and Mr. Wasnitis would like me to talk a little more with Mr. Ziegler about that interplay there. Because we haven't had a ton of time to work out what, if anything, we're going to do. And it may just fall to arguing about day counting and things like that, but we'd like to talk a little more about it.
Okay, how much time?
I think just 30 days, Your Honor, would be appropriate.
Mr. Ziegler?
No objection.
Okay. Mr. Wasnitis, were you able to hear that?
Yes, Your Honor.
Is that how you want to proceed as well?
Yes, Your Honor.
Okay, so we'll set this for a status conference plea hearing in 30 days. Mr. Ziegler, anything else on behalf of the people today?
There you go.
Mr. Travis?
Nothing further, thank you.
All right, so Mr. Wasnitis, between now and the next hearing, you just need to make sure that you stay in touch with Mr. Travis and that you're prepared to make a decision about any plea offers at that next hearing, okay?
Yes, Your Honor.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
Okay, I have Mr. Ross and the AG acted. Mr. Ross, are you able to hear me okay?
Good morning, Your Honor.
Good morning. And okay, Mr. Ross, if you can unmute, please.
Yeah, sorry.
Okay, great. All right, we've got everybody connected. We'll go on the record now in People versus Aaron Ross. This is case number 244882. We have Mr. Wood connected by Zoom on behalf of the state today. We have Mr. Ross connected by Zoom as well. And then Mr. Travis is present here in the courtroom. This is set as a status conference plea hearing today. And Mr. Travis, have we been able to reach a resolution yet in this case?
I believe we have, Your Honor. Largely, if Your Honor remembers, Mr. Ross was dealing with basically trying to figure out what had happened in his home state. After doing some of that and talking to some attorneys, Mr. Ross has decided he would largely just like to accept the Attorney General's offer and start working on paying the arrearage down and deal with his matters with his former employer as a standalone piece. Mr. Wood, when I was speaking to him yesterday, did mention that he'd have to check the numbers, but he thought Mr. Ross wasn't terribly far away from reaching the halfway point of paying back the arrearages. So we had discussed the concept of Mr. Ross entering the plea today, but if prior to sentencing he had made that halfway point, that we would go ahead with sentencing, but that the conviction at sentencing actually enter as the attempt, only if he had actually met their threshold and they agreed to that, rather than asking for another delay to see if that could happen or not. So it's basically the standard plea with a little bit of a caveat that if prior to sentencing he pays the halfway point and the AG has confirmation that it's kind of a critical piece, that they would agree to have the conviction enter as the attempt. So there's a lot of ifs there, but Mr. Wood was kind enough to note that he isn't that far away.
Okay, Mr. Wood, is that a correct statement of the offer by the people here?
It is, Judge. When we charged Mr. Ross way back in 2019, the arrearage was $21,132. Today it's down to $12,819. He's been paying steadily. He didn't pay in April, but he paid in May, and he paid his $6,000 bond over. So the offer is that if he gets to 11,500, so he's at 12,800, so he's $1,300 short of the attempt. So I suggested, or when Mr. Travis and I spoke, that he be allowed to plead today to the principal charge, the felony non-support. If when we come back at sentencing, and if you could set it out, 6 to 8 weeks or however far you can set it out, the better. And he's down to 11,000. At that point, he withdraws his plea and he gets the attempt with maybe the same terms. And then he already qualifies for the delayed sentence, I should say, Judge. Sorry if I'm jumping around here. So we're going to ask you at sentencing to place him on a delayed sentence instead of sentencing him immediately at sentencing. So again, but he should get the straight attempt if he's got it down below 11,500 at sentencing. Does that sound feasible? Is that something we could do, Judge?
Yeah, I don't have any objection to that. Mr. Ross, do you want to proceed with the plea on those terms today?
Yeah, that sounds fine.
Okay. Mr. Ross, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Ross, you understand that the maximum possible penalty that you could face on the principal charge here, which is felony failure to pay child support, is up to 4 years and a $4,000 fine?
Yes, sir.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
So right now you have the right to have, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
I do, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
I do, sir. May I ask, Mr. Travis, this is what we talked about before, right?
It is, and one point to clarify that Mr. Wood pointed out, but to put on the record, if you pay down during the term of the delay to a zero balance, the ultimate conviction they would offer would be a 90-day misdemeanor. I believe it's a disorderly person or is it a disorderly person?
Yeah,
We talked about
disorderly
that.
person, non-support. It's a 90-day misdemeanor. We'd be asking for minimal fines and costs and certainly no probation or jail time, anything like that. If he gets it down to zero, he gets a simple misdemeanor. That's correct. I don't think.
And that is the delay we've talked about, Your Honor, numerous times, but since he asked, I wanted to clarify that.
Sure. Does that clarify things, Mr. Ross?
Yes, I think I can come up with what, the 1,300 in the next 2 months. That would be fine.
Okay.
And again, Judge, if he doesn't, he does have the principal charge, but as soon as he gets it below 11,000, as long as he's paying each month as ordered, he's going to qualify for the attempt at the end. But if he pays it in full, simple misdemeanor.
Okay.
Okay.
All right, Mr. Ross, do you have any other questions about that?
No, sir. Let's clarify. Thank you.
Okay. So I've got a couple other things that I need to advise you of regarding your rights. And that is that you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you'd have to ask the next higher court up, which is the Court of Appeals, to hear your case. If they said no, you wouldn't be able to go with any further with the appeal. Do you understand that?
Yes, sir.
Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
All right, so I'm looking at the information here, and it alleges that between February of 2017 and February of 2019, that you were subject to an order out of Kalkaska County that required you to pay child support. Is that true?
Yes, sir.
And during that period of time, did you fail to pay support either in the amount ordered or at the time it was ordered?
I did, sir, but there was other things that happened. The state of Montana actually is the reason why all this happened. I have all the case numbers. I have everybody's name right here. They clarified that they were taking the money and not sending it to you guys, and it was my fault in the other court's eyes that I did not find that happening and fix it.
All right, so I understand you got all these issues with Montana, but quite frankly, what matters here in terms of this hearing is whether or not you were paying child support here in Kalkaska in the amounts ordered or at the times ordered during that period between 2017 and 2019.
No, sir, I was not.
Okay. All right, thank you. All right, Mr. Wood, are the people satisfied with the factual basis?
Well, yes, Judge, to the extent that he says he wasn't paying as ordered. But if it's true that he was actually paying to the child support collection entity in Wyoming, and they weren't
Montana.
sending it here in Montana, I'm sorry.
It's fine.
And Judge, I've been doing this for much longer than I probably should have. Close to 20 years I've been doing this child support stuff. I've never once seen a situation where the problem was between the child support collection entity in another state and this state. They know how to communicate. Now, I thought he was talking about a potential employer that wasn't sending the money at all. And that's a different issue because that is on him. But so what I would say, Judge, I think we have an adequate factual basis, but if at some point it's determined that he actually was paying as ordered, then that's a whole different deal. I think Mr. Travis and probably Ms. Brenner will be talking, and this would be a dismissal if he was actually paying, but the government was doing it wrong. It sounds like that's what he's claiming happened.
Yeah.
Well, I can talk to Mr. Ross some more, but it's probably more complicated than that because he had other child support cases in his home state.
All right, so that is different. That is different. He's paying money, but it's going to ones he didn't think. Yes, he wasn't paying as ordered in this state. Again, so that thank you for that clarification, Mr. Travis. So I think we do have an adequate factual basis, Your Honor.
Okay, Mr. Travis.
I would agree, and I can talk to Mr. Ross about this more, but the situation is very complicated in his home state. There are issues with his employer, but there is also.
Okay, I'm just gonna stop you, because I've heard this story probably 4 times now, and I'm done with it. Like, we're either gonna go to trial, and that's gonna be an issue at trial, or we're taking a plea today, but I can't hear this story anymore. I know I've heard it many times, and it doesn't matter to me. He's either taking responsibility for what happened here, we're going on with this case, or we're not. So just.
We have, and that's what we're here to do.
All right.
And that's what he's done.
Okay, good. Because I want to go through this whole song and dance again. We've done it.
I'm sorry, Judge.
Okay.
I hadn't heard the song and dance, so I apologize.
No, and that's not directed at you, Mr. Wood. No. And frankly, I think we've had a different attorney from the state for every hearing. So, yeah. So, all right. Okay. So we're satisfied with the factual basis. Mr. Wood, are the people aware of any threats, promises, or inducements other than what we placed on the record here today?
No, Your Honor.
No, Your Honor.
Mr. Wood, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, the people are.
Thank you, Mr. Travis.
Yes.
All right, Mr. Ross, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept the plea. I'm going to set sentencing 2 months out on this case to give you an opportunity to qualify for that reduction at the time of sentencing. Mr. Barrett, how do you want to accomplish the pre-sentence report?
Your Honor, I guess with 2 months out till sentencing, if we confirm between now and then that he's paid the amount down, do you want us to prepare the PSI with the attempt?
I think I just want you to do the PSI with it as charged now, and if it turns out that we've got confirmation at sentencing, then we can address that then. So how do you want to communicate with Mr. Ross?
Just a good phone number, and we can set up a Zoom or just a phone interview, whichever would be easiest for him.
Mr. Travis, do you have a good phone number for Mr. Ross?
I believe I do. It's a 406 area code, Aaron?
Yes.
Okay, yes, I do.
Okay, so Mr. Ross, Agent Barrett or somebody from the probation department here in Kalkaska is going to be contacting you. It's important that you follow through with that contact so that we can have that pre-sentence process taken care of. And then of course, make sure that you stay in touch with Mr. Travis, okay?
Yes, sir.
All right, Mr. Wood, anything else that we need to address for the record on this file today?
So we don't have an actual date yet, Judge. We'll get a notice of hearing.
Correct. Yep. My office will send out a notice of the date and time, and if the state wants to appear by Zoom, just let us know.
I'm sure they will want to appear by Zoom. And Judge, with regard to different attorneys, that's just that's how it's kind of necessary. They do take very good notes, and I knew there was some issue, but I just was a little concerned about what he was saying now. But So thank you very much, Judge. There's nothing more from the people.
Okay, thank you, Mr. Travis. Anything further from your side?
Nothing further. Aaron, I did just give Mr. Bear up your wife's email because he asked for one, just to let you know.
Okay, that's fine.
All right, thank you. All parties on this file are free to disconnect at this time.
Thank you, Judge. Thank you, Mr. Travis.
Thank you.
All right, People versus Flores Campos, case number 244921.
Can I have just like 30 seconds? Thank you, Your Honor.
Okay, the record should reflect Mr. Flores Campos is present here in the courtroom today. If I could have counsel put your appearances on.
Brian Ziegler.
Kyle Travis on behalf of Mr. Flores Campos.
Okay, Mr. Travis, how did we want to proceed in this file?
Your Honor, Mr. Flores waived his prelim on an offer of an attempt, plea in lieu 4th degree, making it a 1-year misdemeanor. One of the things that was still outstanding is I believe blood was drawn, and those results have not come back. And speaking with Mr. Ziegler, he is indicating he was willing to go forward with the offer. And if the results come back, he basically saying that can charge that it's an independent charge. I was just letting Mr. Campos know that. And he would like to go forward with the plea as offered the attempt on the plea in lieu 4th, knowing that there is still potentially a 93 misdemeanor hanging out there.
Okay, thank you. Mr. Ziegler, is that a correct statement of the plea offer?
It is, Your Honor.
All right, Mr. Flores Campos, have you had a chance to talk to Mr. Travis about this plea?
Yes, Your Honor.
Okay, is that how you want to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Sir, are you currently on any kind of probation or parole?
I think it's probation.
Okay.
I was sentenced for 40 hours.
Okay.
Yeah.
Is that done, or are you still working on that?
Still working on it.
Okay, Mr. Travis, do you know if this is going to result in any kind of probation violation?
I'm not 100% sure. I don't believe so. There's a matter, I believe, in the Grand Rapids area that I think was resolved in the interim.
Okay.
I think that matter had started prior to this, but I don't think he had pled, is my understanding. But I'm not 100%.
All right. And Mr. Flores Campos, you understand that the maximum penalty you could face for this charge would be up to 1 year in jail?
Yes, sir.
Okay. How do you want to plead to this charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
Did this, my information said this happened on April 9th of this year, is that correct?
Right.
Okay. On that date, were you operating a vehicle here in Kalkaska County?
Yes, Your Honor.
Okay. And at some point, did a police officer try to get you to stop your vehicle?
Yes, sir.
Okay, did that, was that officer driving a marked police car?
Yes.
Okay, did they have their lights on or siren on or anything like that?
By the time that I realized there was pullover, there was several cops.
Okay. All right, where, did they have their lights on?
Yes.
Okay, all right. And did you fail to stop immediately once you realized that the officers were trying to pull you over?
Yes.
Okay. All right, Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor, but just so the record's clear, this is a chase that went through Antrim and into Charlevoix County. And I just want the record to reflect that I haven't made any promises with regards to any potential prosecutions in other counties.
Okay, Mr. Travis, are you guys aware of that?
We are, Your Honor. I think there's some legal issues with charging in other counties, but specifically what I think Mr. Ziegler's referencing is if Charlevoix wanted to make any charges relative to the actual arrest and what occurred in Charlevoix County. But be that as may, the other issues are legal, but no, it was very clear that he doesn't have any charges from Charlevoix, but Mr. Ziegler is not binding them, nor does I think he really have the ability to bind them.
Right, okay, all right. Outside of that, any other threats, promises, or inducements, Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied the court has complied with statute and court rule in taking of this plea?
Yes, sir.
Mr. Travis?
Yes, Your Honor.
Sir, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. You're going to meet with Agent Bear up here before you leave court today to set up a pre-sentence report. And Agent Bear, if we could just do a misdemeanor, typical misdemeanor report. And then Mr. Flores Campos, make sure that you stay in touch with Mr. Travis prior to your next hearing, and we'll send you a notice of the date and time of that hearing, okay?
Thank you.
All right, thank you. People versus David Starkey, case number 244901.
You're going to have a bit of a moment to go over the PSI with Mr. Sargent.
Sure. Let's take a 10-minute recess. Okay, we're on the record again in People versus Starkey. Mr. Starkey, have you had an opportunity to go through the pre-sentence report and talk to about that?
Yes, I am.
Mr. Travis, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, this is the case. The guidelines are 0 to 11. The recommendation in the plea agreement call for 7411. While the defendant does have somewhat of a lengthy misdemeanor history, he only has one prior felony. I think this is probably his first substance abuse offense, maybe setting aside. I'm not sure if he has prior marijuana, but it's certainly his first felony drug offense. I think he is a good candidate for the 7411 program based on that. Given his guidelines, it doesn't seem like there would be a significant alternative in terms of a different probationary sentence or jail that would be more in his interest or in the public interest to impose. So I think we should give him an opportunity to complete the 7411 program, and hopefully he will take advantage of his opportunities and demonstrate that he can address his substance abuse issue. Thank you.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, I would mirror that as the PSI indicates. He has had substance abuse problems for some time. This is his first charge relative to that. There have been probably many other problems back in Wisconsin that were related to that. He did get clean on his own for quite some period of time. He indicates this was a relapse situation. And he is not only doing the things he needs to do for the court, he's also started with a program to help him with counseling, to work on his sobriety, as he wisely just mentioned to me, trying to work on figuring out why I did this, or the deeper issues, not just staying away, but what's making you want to do this. Which, as Your Honor knows, that kind of is important. It's the next step to staying clean, is working on what drives you to do it. So I think he's taken the matter seriously. His life is quite good. We're discussing family matters. One of his significant others' children just graduated from high school. They've been together for well over a decade. For him, that's a very important milestone. Basically, his own child. He wants to continue to be there. He doesn't want to be using drugs. He's older. He's wiser. So I think he will take full advantage of this opportunity.
Thank you, Mr. Starkey. Anything you wanted to say today?
And I'm truly sorry. You know, being older and more mature and putting people in danger on the road is not me. And I just want to apologize to the community and my kids and my, who I take care of, and everyone that loves me. I hurt them, and I am getting help. And I'm just truly sorry. But I live my life pretty happily, and I bring joy to people at work. I'm not a downer, and I like to make people have a good day at work. I'm a landscaper, and that's my ultimate goal in life, is just to be a good guy and enjoy it and raise kids, and I don't want to go back down that road. And I'm sorry, so thank you for letting me speak.
Okay. All right, I'm aware of the circumstances here. It is concerning from a public safety standpoint that you were operating your vehicle under the influence of some pretty strong substances, and the public danger that presents. I'm sure if you have stepchildren or kids that are driving age, you wouldn't want them to be out on the road knowing that somebody like you is out there crossing the center line and putting them at danger. So hopefully you can relate to how everybody else feels about that situation, and that it is dangerous. I do think, though, that in spite of that, there are indications here that you would be successful on probation, and that you would use this as a learning experience and not repeat this behavior. And so the court's going to give you the opportunity to do that through the probation and through 7411, which would allow this to come off of your public record if you successfully complete it. I am going to impose some jail time and hold it over your head so that there is a consequence if you don't follow through. And it's going to be a really immediate consequence because the holding of jail time in abeyance means that I can impose that at any time if you violate your probation without going through the whole probation violation process, because I've already imposed it, I'm just holding it in abeyance. So I just want you to understand that there's going to be a significant consequence if you're not testing clean, if you're not following all the terms and conditions of your probation. But if you do, of course, the benefit to you is that you don't have to serve jail time and you can have this come off your record. The benefit to the community is we've got somebody now who's back on track, who's not presenting a danger. So there's two sides to that coin, and I hope that we go with the compliance side.
Your Honor, I will do my best.
Good. So the court's going to place you on probation for a period of 12 months. I'm going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to impose, 90 days in the Kalkaska County Jail with credit for 3 days served. That time to be held in abeyance to be served at the discretion of the court. The court is going to order a crime victims assessment of $130, a court cost of $325, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost, along with $30 per month supervision fee while you're on probation. And all of that applies to count 1. As to count 4, the court orders a $53 state cost. You do have the ability to seek an appeal of these sentences, and we're going to provide you with some papers that explain to you what your appellate rights are, as well as have a request a lawyer to help you with appeal. And Mr. Travis, we can have acknowledge those appellate rights. Ms. Wagner, do you want Mr. Starkey to meet with you today?
Yes, he can come over right now. Thank you.
Okay. Okay, so Mr. Starkey, just go across the way, meet with Ms. Wagner, and good luck to you going forward.
Okay, thank you. Thank you.
We have Mr.
Larry.
I'm just gonna have you take a seat. We got one case to take before yours there. Yep, right there. Mr. Elhart, are you able to hear me okay?
I am. Thank you, Your Honor. Can you hear me?
Yes. Looks like your client is connecting right now, so it might just be a minute here. Okay, Mr. Griffer, are you able to hear me okay?
Yes, sir.
All right, we're on the record now in People versus Justin Griffer, case number 244915. The record should reflect that the defendant and counsel are both present by Zoom video. Mr. Ziegler is present here in the courtroom today on behalf of the people. Mr. Elhart, can you tell me where things are at with this case, please?
Your Honor, we've had no significant negotiations regarding pleas at all, but it should be placed on a trial docket. Mr. Ziegler and I will get together and see if there's an opportunity to resolve it short of trial.
Okay, thank you. Mr. Ziegler, Do you need any particular period of time to be ready to go to trial in this case?
Your Honor, I would have asked for at least 90 days.
Okay, Mr. Elhart, is 90 days enough time for you to be ready for trial?
More than enough, Your Honor. Thank you.
Okay, and Mr. Ziegler, how many days of trial do you believe that we would need?
Your Honor, I would set it for 2 days, just erring on the side of caution.
I
Mr.
concur,
Elhart, any
Your Honor.
objections?
No, I concur.
Okay, great. Thank you. Mr. Elhart, are you anticipating any pretrial motions that are going to need to be filed and heard?
No, Your Honor, but if I do, I'll have them filed and heard within the next 30 days.
Okay. Okay, so the court will set this for a 2-day jury trial about 90 days out. I will set it for a final status conference prior to the trial date that will act as the plea cutoff. So to the extent the parties want to negotiate further, that would be the last day to enter into a plea. And then that will also be the motion cutoff. So Mr. Elhart, those motions can be filed at any time, but they would be need to be filed and heard no later than the date of that final status conference.
Fair enough, Your Honor. Thank you.
Mr. Elhart, any other dates I can address for your side today?
No, Your Honor. I appreciate your courtesy today. Do have a safe day.
Thank you. Mr. Ziegler?
Nothing further, thank you.
Okay, thank you. That concludes this hearing. All parties on this case are free to disconnect.
Thank you, sir. Have a nice day.
All right, Mr. Horowitz, are you ready on Mr. Galarno's case? You ready to proceed on Mr. Galarno's file?
Yes, Judge.
Go on the record in People versus Galarno, case number 214552, 224645, 244885, and 244916. The record should reflect Mr. Galarno is present here in the courtroom today, as are both counsel. Mr. Horowitz, how did we want to proceed today?
Apologies, Judge. You called 4 cases?
Yes.
All right, I lost track. My understanding, Judge, is that Mr. Ziegler, on behalf of the people, has extended the global plea offer that resolves all 4 cases. There's been one kind of small tweak to that today, which is that Mr. Ziegler would not be arguing. What did we say? Like, he would leave it to the discretion of the court as to what sentence to impose and whether or not the sentences run concurrent or consecutive. He wouldn't be taking a position.
Just as it relates to whether the sentences would run consecutive, I believe the court will have discretion in that regard.
Okay.
And as I guess we discussed, he won't be jumping up and down saying that they should be consecutive.
Right.
And Mr. Galarno, understanding those 2 small modifications to the offer, that small modification offer, I believe wishes to accept it in a plea, but he's only just now told me that he wishes to accept it. So we did discuss it at length on, well, earlier today and previous occasions and by mail and by phone. But I just now got the indication that he wishes to accept it. So I think we're going to try to enter a plea, but I don't know how it will go.
All right, why don't we start by putting the terms of the agreement on the record and let's see where we go from there. So my first question, and maybe Mr. Ziegler, you can address this first. Are there any of the, so 2 of them are probation violation files, is that correct?
No, Your Honor. File 214552, which is the oldest, is a probation violation file. In that file, he'll be entering a plea to admitting the violating probation based on his other pleas in the other files.
Okay. So as to the other 3 files, then, are there any of those files that are going to be dismissed in their entirety?
No, Your Honor.
Okay, so give me 1 second. Okay, so as to file 224645, Mr. Ziegler, what is the offer? It's the receiving and concealing.
Correct, Your Honor. In that file, he will be pleading guilty to count 1, which is firearms, receiving and concealing. In exchange, count 2, and the habitual fourth offender notice will be dismissed.
And then file 244885.
44885, Your Honor. Be pleading guilty to count 1. Count 1, which is the delivery, manufacture of methamphetamine. Be pleading guilty to count 6, which is a felon in possession of firearm or possession by prohibited person. In exchange,
Okay,
counts.
I'm just gonna stop you because I'm looking at 244885. I show a two count felony information, possession of weapons by a felon and felony firearm.
Your Honor, at some point, we have filed an amended information that would have been on March 18th. That's 9 counts.
Got it. Sorry. Mistake.
Sorry, Your Honor.
Okay, so he's gonna plead guilty to count 6.
Count 1 and count 6. Your
Got
Honor. And then in exchange, all other counts in that file and the habitual 4 will be dismissed.
Okay. Thank you. And then the last file, 244916.
File 244916. Defendant will plead guilty to count 1, which is assault with intent to do great bodily harm, less than murder by strangulation. In exchange, count 2 and the habitual 4th mandatory 25 will be dismissed.
Okay. Thank you. And then the only other condition of the plea offer is that the people will take no position with regard to consecutive sentencing as to any that apply.
So we would agree not to take any position and leave to the discretion of the court any consecutive sentencing issues. We would also agree not to charge any other charged offenses that arise out of any of these files, charged or currently charged or uncharged.
Okay. Thank you. So Mr. Horowitz, is that the plea agreement that you've discussed with Mr. Galarno?
It is. Mr. Galarno is indicating that it is. He has a copy of the email, the offer in front of him. He was reading over this. Mr. Ziegler went over it. I confirmed that that's what's on paper, plus our modification tweak today, plus what Mr. Ziegler just added about no additional charges for misconduct.
Okay, so Mr. Galarno, is that correct? Is that the agreement that you've discussed with Mr. Horowitz?
As far as I'm aware of, yes, sir.
Okay. Is that how you want to proceed today?
It is.
Can you raise your right hand, please? As best you can. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Thank you. You can lower your hand. All right, Mr. Galarno, I'm going to go through all the maximum penalties that you could face for these charges with you here on the record. So first of all, looking at file 224645, 1 count of receiving and concealing a firearm. That is a felony that carries with it a maximum possible penalty of up to 10 years and or a $5,000 fine. Do you understand that?
Yes, sir.
File 244885, 1 count of delivery or manufacture of methamphetamine. That's a felony that carries with it a maximum possible penalty of up to 20 years and or a $25,000 fine. Do you understand that?
Yes, sir.
In that same file, 1 charge of possession of a firearm by a felon. That is a felony that carries with it a maximum possible penalty of up to 5 years and or a $5,000 fine and mandatory forfeiture of that weapon. Do you understand that?
Yes, sir.
In file number 244916, 1 count of assault with intent to do great bodily harm less than murder or by strangulation. That is a felony that carries with it a maximum possible penalty of up to 10 years and or a $5,000 fine. Do you understand that?
Yes, sir.
And then on your probation file, by pleading guilty to that assault charge, that will also result in a finding that you violated your probation in file 214552. And that could subject you to a maximum possible penalty in that case.
It's a life offense, Your Honor.
Okay, of up to life. Do you understand that?
Yes, sir.
Also, because one or more of these charges occurred while you were on bond for another charge, the court has the option of sentencing you consecutively, in other words, back to back, as opposed to running at the same time. Do you understand that?
Yes, sir.
Okay. With all of those things in mind, what is your plea to each of those charges here today?
Plead guilty.
All right. So right now you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand that you have all those rights with regard to all of these charges.
Yes, sir.
And you understand that you're going to be giving up and waiving all of those rights and you won't have them anymore.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal this plea, you'd have to ask the next higher court up, the Court of Appeals, to hear your case. They could say no, and that would be the end of any appeal. You understand that?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
Okay, so I'm going to start with the oldest charge here, and that is the charge of receiving and concealing a firearm in file 224645. And the information in that case indicates that that took place back on December 17th of 2021. Do you have any reason to doubt that's the correct date?
No, sir.
On that date, were you present here in Kalkaska County?
Yes, sir.
All right, and did you have possession of a firearm at that time?
Oh,
Somebody give you a firearm or sell you a firearm that you knew was stolen or had reason to believe was stolen?
does, what case number? I'm sorry.
This is 224645 back in December of 2021.
Yes, sir.
Okay, what kind of firearm was that?
I believe it was a 22.
And did that occur here in Kalkaska County?
Yes, sir.
Mr. Ziegler, as to that charge, any issue with the factual basis?
Your Honor, I didn't hear him acknowledge that he had reason to know the firearm was stolen. I know the court asked, but I don't think he actually answered the question.
Okay, Mr. Galarno, did you know that that was a stolen firearm?
Afterwards, I did.
Okay.
I acquired information that told me that it was stolen. And that was like within a couple of days. The individual that gave it to me didn't tell me at first, even though I assumed. And he just confirmed it within about 2 days.
Okay. You assumed that it was stolen though? when he gave it to you? Okay.
I'm satisfied with that.
And at the time he learned that it was stolen, it was still in his possession and he did not get rid of it.
Okay.
Is that correct?
Yes, sir.
Mr. Horowitz, are you satisfied with the factual basis on that charge?
Yes, Your Honor. Thank you.
right, the next one, Mr. Galarno, is the charge for delivery or manufacture of methamphetamine. The information here states that occurred on December 21st of 2023. Do you have any reason to doubt that date?
No, sir.
And on that date, did you have possession of some methamphetamine?
Yes, sir.
And were you here in Kalkaska County at that time?
Yes, sir.
Did you give or sell that methamphetamine to another person?
I had. Yes, sir.
Okay. Did you have any legal right to do that at the time that you did?
No, sir.
And at that time, were you also in possession of a firearm?
Yes, sir.
And were you ineligible to be in possession of firearms due to a prior conviction that you had? Mr. Ziegler, as to the factual basis there.
I'm satisfied.
I'm satisfied. Thank you.
And then Mr. Galarno, the last one, that's the incident that occurred on March 15th of this year. With regard to Samantha Galarno, do you recall that incident?
Yes.
Okay, is that the correct date?
Yes.
All right, and did that occur here in Kalkaska County?
Yes.
All right, and did you assault Samantha Galarno on that date?
Yeah.
All right, and Mr. Ziegler, is the basis here the strangulation part of this, or was there some, I don't know what the actual.
I would say it could be either, Your Honor.
Can you ask a few questions, since I don't know the underlying facts?
Mr. Galarno, on that date and time, you were in Kalkaska County,
Yes, sir.
and you made an assault, or you struck Ms. Galarno?
Yeah. Yes.
Yes. And as part of that assault, did you cause her some significant injury?
I don't know.
As part of that assault, did you put your hands at her neck?
Don't recall. Possibly.
Would you agree that you may have restricted her airway in some way during that assault?
I don't recall, but possibly. Yeah.
Did you ever have occasion to see photographs of Ms. Galarno's injuries following that assault?
Kind of, yes.
Would you agree that they were significant such that they would have required some medical attention to
Yeah,
treat?
it didn't look very nice.
You're all right. I think that probably establishes the factual basis, at least to assault with intent to do great bodily harm.
All right, and you were the one that caused those injuries, Mr. Galarno?
Yeah.
All right, Mr. Horowitz, are you satisfied with the factual basis?
Yes, sure.
Okay. And Mr. Galarno, at the time that occurred in March of 2024, were you on probation here in Kalkaska County?
Yes, sir.
Were you aware that one of the conditions of your probation was that you were to not violate any laws of the state of Michigan?
Fully aware.
All right, thank you. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Horowitz.
No inducements or threats, other than I did go over his guidelines with them, did explain the effect that habituals would have, did explain the effect of the 25-year mandatory minimum, and did, explain those in terms of the benefit that he would receive from the plea offer.
Thank you. Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Horowitz.
Yes, sir.
All right, thank you. Mr. Galarno, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of the charges. The new charges in each of these files. The court's also satisfied there's a factual basis to support a finding that you did violate your probation as alleged. In that file, the court will accept your guilty plea as to all charges. We will set this matter for sentencing hearing. You'll be notified of the date and time of that hearing. In the meantime, we'll have a pre-sentence report prepared. You'll have an opportunity to go through that with Mr. Horowitz. Mr. Ziegler, anything further that we need to address today?
No, Your Honor.
Mr. Horowitz.
No, thank you.
All right, thank you. That's all on this matter.
Hey, David. Okay, sorry about that. Oh.
See what they did to the train. Field just can hold me. Okay.
Also, you said.
Oh, maybe.
Is it,
Yeah.
it's afternoon?
No, it's this morning. 11:30.
I just have to pull it open, sorry.
Ma'am, can you tell me your name there at Wexford?
It's Sarah Helsel.
Okay, Ms. Helsel, we just have, I believe, one case, maybe two cases in front of yours, so I'm just gonna have you remain on the line here, okay?
Okay, thank you.
Thank you. All right, we'll go on the record in People versus Fields. This is case number 234870. The record should reflect Mr. Fields is present here in the courtroom today. Executive counsel, put your hand on. Mr. Horowitz, are you ready to go forward?
Yes, sure.
Okay, Mr. Fields, if you can come up to the podium there, please. Mr. Fields, have you had a chance to go through the pre-sentence report and talk to Mr. Horowitz about that?
Yes, sir.
Okay. Mr. Horowitz, I know we may have already done this. Are there any additions, deletions, or corrections that need to be made?
There's not here.
Any challenges to this one?
No.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, I think that the court is well aware of the factual and procedural history in this case. We were here once before for sentencing. At that time, we went back and renegotiated the agreement that Mr. Horowitz and I reached because that the people would support the recommendation, which was a sentence to 1 year incarceration in Calcasieu County Jail. I think given the nature of the conduct in this case, that's an appropriate sentence. So I would ask the court to adopt the recommendations contained in the PSI, adopt that sentencing agreement Mr. Horowitz and I came back to the court with, and sentence him to a county time sanction. Thank you.
Agent Barrett, do you have I'm not sure if I have the up-to-date jail credit.
I do, Your Honor. Yeah, can I, let me present this to you?
Sure.
Okay, coming from approach. I've made a note down here. He really has no credit because the bond was never canceled.
Okay,
So,
got it. All right, thank you. Mr. Horowitz, anything on behalf of Mr. Fields today?
Well, mostly we hope that the court agrees to the 12-month agreement. Understanding that this is probably a more significant criminal transaction than county time usually pertains to, but I would point to Mr. Fields' youth. He's still very young. He is not fully matured neurologically, developmentally. He would have been given the benefit of a HIDA sentence if the court had agreed, but for Mr. Fields' rather significant criminal juvenile history. You know, people similarly situated, well, excuse me, co-defendants are receiving probationary sentences. Seems likely in any case. So I think the year will accomplish what it needs to in terms of sentencing criteria. That said, Mr. Fields still has several other cases open in other counties where some of them look like there's plea agreements on the table for a year, and some of them look like they might be significantly longer amounts of time. It's really hard to say, and not. He's still got a road ahead of him, I guess is what I would say. So I think if the court agrees to the year, that might be almost academic in terms of he might still be in regardless. But in terms of credit, I mean, to my mind, Mr. Fields has been in custody for the life that I've had the case. So I don't remember a decision on his part to not cancel his bond. I don't know if
I
that's
asked him my bond to be canceled.
okay. So we asked at a hearing for bond to be canceled.
Yeah, I asked him my preliminary hearing with the other judge, my bond to be canceled.
Okay.
And she said, okay.
So he thinks that Ms. Boudet must have canceled, excuse me, I'm saying Ms. Judge Boudet must have canceled his bond at the preliminary hearing.
Looking at the order from the date of the bind over following that hearing, and the boxes checked, it says it's done.
Yeah, bond was posted in February of 2023, and it was continued following bind over, so I don't see anything in the file where bond was ever canceled. That's never was canceled.
My fault.
What's that?
So it's basically my fault.
I don't know whose fault it is, but the file doesn't indicate that your bond was ever canceled.
So I won't get none of my time credited.
No.
And if you did ask and it is in the transcript, we can go over the transcript afterwards. Or we can ask for a transcript and review it and determine whether it might occur.
All right, Mr. Horowitz, anything further for allegation?
Other than what I just said, I think that, regarding bond, I don't know that it would make sense to deny Mr. Fields credit if he thinks his bond was canceled. I think the court could ask or could order that it be canceled non-pro-tunc. He's been in the entire time I've represented him, and it's never been raised as an issue that I recall. So I think it'd be somewhat of an injustice to deny him credit when he thinks that that he was earning credit. I think that had I been aware, he'd been aware, it's something that would have been addressed. Of course, the way I get into these cases is vis-a-vis a conflict. So I'm not aware of what happened early on, but I would ask the court just to non-pro-tunc issue an order that bond was canceled retroactively, and that Mr. Fields should get credit because he has been in.
Thank you. Mr. Fields, anything you wanted to say today?
Full responsibility for my actions. Sorry to the victims that broke to tried to break into the dispensary. And I just want to just get this stuff over with and continue forward with my life. I want this for my life. I don't want to be incarcerated in my life. Change plans when I do get out. Just do better in the community and conduct myself positively in the community.
All right, I did read through the report, obviously, before the last hearing as well as before today's hearing. So I'm familiar with what happened in this case. I also presided over the cases of a couple of the co-defendants that were involved in this incident. And so I'm aware of all the circumstances involving the crime here, as well as your background, which we've all, acknowledged is not good. You've developed fairly lengthy criminal history given your age. A lot of that as a juvenile and continuing now into your adult years. So if you are going to make a change, now is the time to do that, because otherwise every charge that you get from here on out, you're going to wind up with some higher and higher guidelines because of your past record is going to start catching up to you. While I didn't think HIDA was appropriate because of your past record, I do think that the 12-month recommendation is appropriate given the circumstances here. Although the guidelines could call for a sentence of up to 24 months in prison, given the nature of the crime here and your role in it, I think 12 months is adequate to punish the conduct and to provide a consequence for that. So the court is going to follow the sentencing agreement and sentence you to 1 year in the Kalkaska County Jail. The court is going to grant 1 day of jail credit if you're able through your attorney to provide some evidence that bond was canceled. Then the court will of course give you credit. But as it stands now, for whatever reason, neither you or any of your attorneys filed an order to have bond canceled in this case. You are going to be ordered to pay a crime victim's assessment of $130, court costs of $350, attorney fees of $325, and a $68 state cost fine of $100, and that's as to count 1. As to count 2, 1 year in the Kalkaska County Jail, again with credit for 1 day served, those 2 sentences to be served concurrently, and a $68 state cost as to count 2. You do have the ability to seek an appeal of these sentences. And you can provide an acknowledgement
I don't get my time credit. I'll withdraw my plea.
File a motion on that.
Okay. Because I've been locked up 12 months. I had a hold. My hold never been lifted. None of that. So
This is,
I couldn't bind out because I had a hold here.
this is your.
I want to appeal my sentence.
That's okay.
I want to do it. If I ain't get my time credit.
So, listen, judge is going over this form with you, right? Today is what, 4? You sign this, this is your acknowledging that you received, right? What you do, if you want to, fill out the rest of it, you fine. Right? You just sign there. Right? Right now, they need this, just indicating that you. This goes with you.
Okay,
And so, thank you.
All right, People versus Jeremy Knoll, case number 234798. Mr. Knoll present.
Mr. Knoll is in Grand Traverse Jail, I believe.
It's a Zoom hearing.
Grand Traverse.
One of the previous times, I think it had moved to Benzie, but I think he's back here.
Mail to Grand Traverse. Well,
Your Honor, we did rid him for today's date. We did email someone to Grand Traverse Sheriff's Department. They confirmed receipt of the writs on May 30th. That date was there and everywhere.
okay, well, counsel, how do you want to proceed today? Because I don't see Grand Traverse signing on, and we're well past the time for hearing in this case.
But I think this is not likely to resolve today anyway, given Mr. Knoll's situation. I think that there was a potential agreement to resolve it, but it was based on some violation was based on some things that are still open. Mr. Knoll had been trying to resolve those through, I guess you could say, alternate means, but then was imprisoned in Traverse on another case, so it kind of threw a wrench in the works. So I just asked to adjourn it, Judge.
I don't see that we have any other alternative.
All right, and Mr. Ziegler, I'm just gonna ask that the people prepare a writ for Mr. Knoll to be transported here for that hearing. We've had enough issues trying to get him on video that I think it's time to just have him transported so that we can actually proceed on that case. And then the court will reset it for a hearing.
Yes, sir.
Thank you. Okay. People versus Sarah Marie Helsel, case number 234824. We have Ms. Helsel present by Zoom video from Wexford County. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of people, Your Honor.
Ryan Mason on behalf of the council.
So this is set for a hearing today. Ms. Helsel was picked up on a bench warrant earlier in May. Both defense counsel and defendant failed to appear for a hearing in May on this case. So the court set it for a show cause and then issued a bench warrant for Ms. Helsel. She has since been apprehended. Mr. Mason, I understand that you did file a motion to withdraw.
That is correct.
But first of all, can you address the non-appearance at the last hearing?
Sure, Your Honor. I first of all, I'd apologize on my behalf and Ms. Helsel. I think we just didn't get notice or something happened. We've had a number of hearings in this matter that have been adjourned because of a ongoing request for a criminal responsibility exam that precedes my time in this case. I think that was originally entered in like February of last year. She did give a health competency trial last May with Judge Boudet. But I think what happened here, the notice we didn't get it somehow, which is odd because we've gotten the other ones. We've always stick to adjourn and the people have been really accommodating. I'm not sure at this point if the forensic center is still moving the direction for exam. So I'm not sure if that's something that needs to be revisited at some point or a new order needs to be submitted because they seem to be not doing anything. Sure. And even for them, I had another one submitted, another case. I think January of this year, that the guys actually have a hearing today. They sent me a notice of the hearing. This case, I think they were supposed to do hers this past January, but no notice ever went out. That's what they told me earlier over the phone, but we never, that doesn't count, you know, so that's the issue. I don't think her failure to appear was intentional. Mine certainly was not. I don't think if we were here, we could have resolved it anyway, if they're still in an exam. But we would ask the court to reconsider reinstating her bond. As far as I know, she's been pretty compliant with her bond conditions throughout this case. There was a mix-up a year ago, May, I think, with the hearing to hold her competent, where she might not have come in, but they eventually brought her in, and we took care of that. I know she's getting treatment for with the methadone clinic, and she's got mental health treatment she's going through. I don't know how this case is going to resolve. It's 4 felonies that are 4 and 5 year ones. They're not horrifically, serious as far as time. But we'd ask the court to strongly consider reinstating her bond, so she can be out and deal with this case, as well as other things she's got on her life.
Okay, and are you still seeking to withdraw?
I would at this time, Your Honor, yes.
Okay. Okay, Mr. Ziegler, what's your position on how we should proceed?
Your Honor, in terms of the bond matters, I would just point out that this is not counsel's first failure to appear in this case. My notes have her failing to appear for the last hearing in May. She failed to appear in December of 23. She failed to appear in June of 23, 2 different dates. So this is not the first time where there's been perhaps some mix-up or a notice has been lost or whatever reason that does not appear in this matter. I do understand that this case has been going on for a long time. There have been a lot of dates, but I do think that it strains credulity to believe that all of these are mere accidents. And I think reinstating her bond does not send the correct message to her or to other similarly situated defendants. So I would ask the court to forfeit her bond and set a new bond in this matter. In terms of defense counsel's motion to withdraw, I don't take a position on that, Your Honor.
Okay, Ms. Housel, do you oppose Mr. Mason withdrawing as your attorney in this case?
No, I don't.
Okay, are you going to, you understand that you do have the right to have an attorney at any subsequent proceedings?
Yes, sir, I do.
And you understand that if you can't afford an attorney, one would be appointed for you?
Yes, sir.
Did you want to hire your own attorney or did you want to request a court-appointed counsel?
At this point, I don't have any more money to be able to put out for an attorney, so I'm gonna have to do a court appointed.
Okay, so the court will refer your case to our local appointing authority for evaluation and appointment of counsel. The court will set this for another status conference in about 30 days, once counsel has been appointed and you've had a chance to talk to your attorney. Mr. Mason, the court will grant your motion to withdraw. Did you submit an order with your motion?
No, can I email it to your clerk later?
Yes.
I'll get that today. Just wanted to see what she was gonna do with the new, but I'll get that to you.
Okay.
I'll have it today.
And then, so then the court again will refer this for appointment of counsel. I do think, Ms. Housel, you are entitled to a bond. You have had numerous problems with appearing for hearings in this case. And so.
Your Honor, can I say something?
Sure.
I do have informed delivery on my mail that I had the same address to show that I have not been receiving anything.
Okay, have you tried contacting the court to find out when your hearings are?
I have not contacted the court, but I have contacted Mr. Mason through text.
Okay, have you told the court that you're not receiving any mailings from the court?
I just assumed I didn't have court because of the fact that Mr. Mason didn't receive anything.
Okay, well, you know that you have a case in court, right?
Right.
Okay, and when you don't hear anything from the court for months on end, you just assume that you don't have any court dates?
I just assumed it was adjourned. I mean, I put all my faith in my attorney, you know?
Okay. Well, you know, given the number of times that you failed to appear, I just don't believe that you're not receiving notices or you don't know that you have court. And if you're not receiving it, I don't believe that it's, you know, it's appropriate for you to just not show up and not contact the court. The responsibility is on you to appear for court when you're supposed to be here. And if you're not getting notices, the responsibility is on you to figure out why and to remedy that situation, particularly when it's happened numerous times.
I only know of one other time that it had happened, and I turned myself in after the fact. I was in the hospital in heart failure.
Yeah, well, I've got at least 3 times that you failed to appear for hearings, so.
And I know that there was one time that was getting switched from the court-appointed attorney to Mr. Mason, and nobody got notice on that.
Yeah, well, somehow everybody else gets their notices, so again, I just don't believe that it's a problem with you getting notice. I think it's a problem with you not taking it seriously and not making sure that you know when your court dates are and being.
But that's the thing, I am taking everything seriously. I put myself in treatment. I pay to do my stuff. I do my therapy. Like, I built relationships with my kids. I've done everything I'm supposed to be doing.
Okay, except showing up for court when you're supposed to be here, so.
Then that would be just stupid not to show up for a show cause hearing. I mean.
I totally agree. That's why I don't know why you're not doing it.
Because I didn't know. My husband's got my phone that shows that I didn't get no notice.
Yeah, all right. So your previous bond was $10,000, 10%. The court is going to set bond in this case at $15,000 cash or surety. And you'll be subject to all the previous conditions of your bond. If you are released and you're able to post bond, you need to make sure that you provide an updated address with the court. And whatever address you provide is the address that the court will be sending notices to. If you're not able to post bond, the court will send your notices to the jail. And then you'll also be informed of whether or not you qualify for a court-appointed attorney and who is appointed to represent you. And you'll have an opportunity to speak with them prior to your next case.
Okay.
Mr. Ziegler, anything further today?
No, Your Honor.
All right, Ms. Housel, do you have any other questions?
So am I understanding this right? That there's a new bond, right?
Correct.
Okay. All right, no, I think I'm good on all that. Thank you, sir.
Okay. All right, thank you. That's all for today. And the court's going to disconnect at this time.
All right, thank you.
Thank you. Thank you. Okay, we've got an arraignment for Crawford County, and then Seeger, do you know, is Mr. Armstrong, is he lodged?
He is in the holding.
He is large. I'm not aware of it. It just said that he was going to appear in person.
We can bring it up.
Yes, sir.
Oh.
It's a 3-month.
So Mr. Thompson, I just got one other quick arraignment I need to do. We're running a little bit behind, but if you just stay on the line here, we'll get to your case in just about 5 minutes, okay?
I don't know if he's got any papers.
Mr. Seeger, did you need any time to talk to Mr.
Your Honor, if you wanted to take care of Mr. Thompson's file, maybe I can. I thought he was coming here first. Just.
Okay, Mr. Thompson, we are gonna go ahead and take your case now. It looks like you guys are muted. I don't know if you can unmute there. Let me try this. Hold on a second. All right, Mr. Thompson, are you able to hear me?
Your Honor.
Okay. And we have Ms. Cope present. Okay, so we'll go on the record in, this is Crawford County District Court Case 2417488-FY. And this is People versus Justice Lemke Gentilla. Mr. Gentile is present today for this hearing by video from the Crawford County Jail, along with on-duty counsel, Mr. Thompson, for purposes of arraignment. We have Ms. Cope present by Zoom. On behalf of the people, the court's presiding over this case on behalf of Judge Burmeister for purposes of arraignment. Mr. Thompson, have you been able to go over the charges with your client today? Mr. Thompson, it sounds like, I don't know, we're not able to hear you.
Sure what to say about that.
It keeps going in and out, like I'm getting a couple words. We're still not able to hear you.
I don't have any ability.
Yeah, I'm not really able to hear what you're saying, unfortunately.
Can you hear?
Again, it just, I'll get like one word and then it cuts out.
Yeah, I got a text message from Mr. Thompson that they're going to move him into the library so that they can fix the audio feed issue.
Okay, great. Thank you. Mr. Seeger, we're at a standstill on our other one.
I'm all set.
Okay.
Your Honor, I did have an opportunity to have Mr. Armstrong fill out an application for the county council.
Okay.
He also did execute an advice of rights. I don't know if he gave the advice of rights, but he signed it anyway.
All right, so this is People versus Armstrong, case number 234838, and this is a arraignment on probation violations. Mr. Armstrong, do you understand why you're before the court today?
Yes, Ron.
Okay. And have you been made aware of what the alleged violations are?
Yes.
Well, just need to go through a few things with you with regard to your rights. First of all, you do have a right to have a hearing as to whether or not you should be found guilty of violating your probation. You also have the right to have an attorney present in any subsequent proceedings. If you can't afford one, one would be appointed for you. If you are found guilty of violating your probation, it gets subjected to the maximum penalty underlying charge, which is your underlying charge is attempted breaking and entering. That charge carries with it maximum penalty. Anybody? Mr. Sheriff, you have that?
Carries a 5-year max.
Okay, up to 5 years. Do you understand all those things I've just stated to you?
Yes, Your
Okay. Mr. Seeger, how does Mr. Armstrong want to plead?
Your Honor, he would plead not guilty, and then I would approve his request for an attorney, and I would assign Mr. Travis, just for the court's notice, but I would assign Mr. Travis the notice.
Okay, thank you. And Mr. Travis was the prior attorney, is that correct?
He was, Your Honor.
So the court will enter not guilty plea on behalf of Mr. Armstrong. The court will set this for a hearing at its next available date on the probation violation. As to bond pending that hearing, Agent Barrett, any input on that?
Yes, Your Honor, given the nature of the alleged violations, the department would recommend no bond. I think he does have, in regards to the new criminal charges in Calhoun County, I think there's a prelim hearing scheduled for June 21st in that matter to the RNO.
Okay. Thank you, Mr. Seeger.
And Your Honor, I would just ask the court to consider giving him a PR bond or a very relatively low bond. And as much as I understand that there's a probation violation, one, I did tell him that I would probably ask the court to adjourn this hearing until such time that he can in Kalamazoo. And additionally, Your Honor, in Battle Creek, Your Honor, to the extent that they're able to be resolved, he's intending on going forward with the trial or proceeding there, so I'm not entirely sure what will happen there. Additionally, Your Honor, my understanding is that he has a PR bond there, but he's required, once released from Kilcasca, to immediately report to their court system. So I assume that he'll do that. I don't know him to be a flight risk in any way. He's clearly here. I don't know how he got here, I guess, but I do know that he's here. And I don't know as if he's like failed to report in the past, because the allegations are related to new criminal conduct, I assume. They're both on 5/10 of 24, so I assume it's related to that. So I don't know if there's what's going to happen with a criminal case, but in ordinary circumstances, where somebody picks up a new file, we usually would ask to adjourn the probation violation until such time that the underlying charges are resolved. If he's convicted, well, then that's dispositive. If he's found not guilty, it doesn't mean that the court can't violate him if it has a hearing later, but it definitely is something that the court would consider at a later date.
All right. I think Mr. Armstrong is entitled to have a bond set. Given the nature of the underlying charges, the court is going to set bond in the amount of $10,000 cash and surety. And the conditions of bond will be all standard conditions along with all the terms and conditions of probation. And then the court will set this for hearing again at its next available date.
The other thing that he asked, and I understand what you just said, he wanted the court to know that he's required to wear a tether downstate.
Okay. Again, that doesn't change the bond conditions here. You can talk to Mr. Travis. You can talk to Agent Barrett. Maybe there can be some agreement regarding bond going forward, but at this time, I think an appropriate amount given your underlying charges in this case and the alleged violation is again $10,000 cash and surety. And that's all for today's hearing. Thank you. What's that?
Can I approach her?
Yes.
I don't care if Ryan comes up there.
I have questions.
All right. So the lady, I don't even know what her name was, like. I don't know if she would ever, I don't know. Yes,
I'll put that into my notes, Jen.
okay, so she'll send me something, yeah.
Mr. Thompson, are you able to hear me?
I can hear you, yes, Your Honor.
Okay, all right. Are you able to go with your device and be with Mr. Gentilla there so that we can hear him as well?
I will try that, yes.
Okay.
And just so the court is aware, the issue we're having is you hearing us, not us hearing you.
Right, correct. Yeah, I wasn't able to hear you. It would come through like one word at a time. Okay, all right, so we're back on the record in People versus Gentilla. And let's see if we can get Ms. Koch back now. Here we go. Okay. So Mr. Thompson, I was inquiring whether or not you had an opportunity to go through the felony complaint with your client.
Yes. Waive reading and stand.
Bad. I don't know why we're getting, hold on a second. Let me try something else here. Okay, Mr. Thompson, can you try that again?
Can you still hear us?
Yep, that's better. Okay, I think I solved the problem.
All right, thank you, Your Honor. Yes, we would waive a reading, stand mute, and ask that a not guilty plea be entered as to each count.
Okay, so the court will enter not guilty plea on behalf of Mr. Gentilla as to all counts in the felony complaint. That's 7 different counts. The court will set this for a felony pretrial on June 11th at 1 p.m. and a preliminary exam on July 2nd. At 2 p.m., the court will provide written notice of those dates to both Mr. Gentilla and has he already been screened for qualification for counsel?
Yes, he's been screened and I will be appointed as his court-appointed attorney.
Okay, so the court will provide written notice to both counsel and Mr. Gentilla as to those dates. In terms of bond pending those hearings, Ms. Koch, do the people take any position with regard to bond?
Yeah, I think bond is appropriately set at this time. I talked to Mr. Thompson briefly. I understood he would be appointed in this case. We have a bunch of ongoing investigation that's happening really as we speak, yesterday, tomorrow, and such that are scheduled. So I don't have as much information as I would like. Mr. Gentilla is a member of this community. He does not have much of a criminal record. The allegations in this case, and I can go over what they are right now. There may be more coming.
Thank you, Mr. Oh, go ahead.
So the allegations involve multiple minor children, ages 15 through 17. Thank you.
All right, what are the people asking or recommending in terms of bond?
Yeah, I believe the bond is set at $50,000 right now, and I think that's appropriate.
Okay, thank you. Mr. Thompson?
We are asking the court to consider reduction of bond. We don't dispute that these are serious allegations, that there were illegal messaging occurring. That's a serious allegation. There's no allegation at this point of anything beyond that, but we acknowledge that's a very serious allegation. We are asking the court to consider a $10,000 or $20,000 cash bond. Mr. Gentilla has historically been employed with the state of Michigan. He is local. He's lived here his whole life. His parents live here. He's well enmeshed in the community. He has a lot of people who are willing to help him with this bond situation. I think to protect public safety, the court could restrict and not allow him to use internet access and not use a cellular phone. The court could also consider doing daily PBTs, which I understand may be a piece of what Mr. Gentilla is going to be dealing with as he, what he may be dealing with in this case. But I would ask the court to consider a reduction of bond to $10,000 or $20,000. Thank you.
All right, thank you. I did have a chance to review the felony complaint. While certainly the factors described by Mr. Thompson are mitigating factors in terms of the amount of bonds, the court finds aggravating factors include the number of charges, which are 8 different counts, the nature of those charges, which involve minors and sexually abusive activity. The maximum possible penalty of at least one of those charges is up to 20 years. So there's a significant penalty if Mr. Gentile is eventually found guilty. All of those things, I think, warrant a continuation of the previous bond that was set, which is $50,000 cash or surety. That previous bond also contains what I find to be appropriate conditions regarding not contacting the alleged victims in this case and not using any computers or electronic devices to access the internet. So the court will continue the bond as previously set by the magistrate. And again, we'll proceed with the next court date on June 11th at 1 o'clock.
Thank you.
Ms. Koch, anything further we need to address for the record today?
Not at this time. Thank you, Your Honor.
Mr. Thompson?
Nothing further at this time. Thank you.
All right, thank you. That concludes this hearing today. It also concludes the court's morning docket.